Good morning, guests. Looks like we have some new issues because we have some new people in the audience. Welcome to the Committee on House Natural Resources and Environment. Today is May 27th, 2020. Madam Secretary, please call the roll.
Chairman Coussan?
Here.
Here. Vice Chairman Boyack? Here. Representative Butler? Here. Representative Carrier? Representative DeVilliers? Here. Representative Desatel? Here. Representative Kerner? Here. Representative Landry? Representative Lyons? Representative Mincy? Here. Representative Reiser? Here. Representative Romero? Here. Representative Wheat? Here. 10 members are present. We have a quorum.
Thank you, Madam Secretary. And I know Representative Landry and Representative Carey are both on their way for those of you looking to hear from them today. A reminder for our new guests, please silence your cell phones. If you'd like to take a call, please step out of the room. If you'd like to provide testimony, submit a witness card. Green is in support, red is opposed, and white if you wish to provide information only. Fill out the card in its entirety. Your signature is an affirmation that the testimony you provide is accurate to the best of your knowledge. Please leave your card with the Sergeant-at-Arms who are going to be walking through the audience. In an effort to protect each other from COVID-19, please don't congregate in the hallway too much. And for our members, we're asking for you to stay seated as much as possible and not to congregate in the anteroom. We have a guest to start out our day, and we did start a little bit early to take care of this before we get to the bills. We have a guest, Cheston Hill, if you don't mind coming to the desk. Cheston is from the State Lands Department and would like to introduce himself to the committee. Mr. Hill.
Thank you, Mr. Chairman, committee members. My name is Cheston Hill. I'm the administrator for the Office of State Lands. It's a pleasure to be here today. I thought it would be good to come in for introductions. I know that a number of you are new to this committee, and I'm actually new to the position of administrator. But this committee and our office often work together on things. There's often a number of bills that come before this committee each session with a subject matter that involves the State Land Office to some extent. And we like to make ourselves available in the event you all have any questions that we can answer or any concerns that we can assist with. So it's a pleasure to be here. I want to tell you all a little bit about the State Land Office, and I'll try and keep it brief. We're responsible for the identification, administration, and management of state public lands and water bottoms. Now, what that refers to is not all state property, of course. The majority of what we manage is referred to as sovereign lands. That includes the bed and bottom of natural navigable water bodies, as well as similar types of property, accretion on the Gulf of Mexico, dried lake beds that were once navigable, and that sort of thing. It's roughly 5.5 or 6 million acres of that sort of thing in the state of Louisiana. We also have some tracts that are remnants of the early public land grants from the federal government to the states that remain unsold, and we have some holdings that were donated to our office by private individuals over the years. The primary goal of our office is to ensure the highest economic return and the maximum public use and best protection of our holdings, and we do this through permitting, leasing, timber management, and good stewardship. We have a number of other functions we perform to serve the public and other agencies also, as I'll describe in a moment. We're a small office with only 18 people. We're entirely self-funded through self-generated revenue, and we're an office of the Division of We're an office of the Division of Administration. We have 4 sections. We have the administrative section, the historical records section, the titles and surveys section, and the land and water bottom management section. I want to tell you a little bit about each real quick. The administrative section is our smallest section. It's really just the administrator. I became administrator back in February. I work on behalf of the commissioner with delegated authorities, and I oversee the operations of the office generally. The historical records section has 3 primary functions. It serves as the custodian of the state's historical land, title, and survey records. These are the records from the 1800s evidencing severance from the sovereign, which is where all land title originates. We assist folks like landmen, abstractors, and title attorneys, typically from the oil and gas sector, with locating and providing copies of these records as a part of their record title research. The Historical Records section also manages the SLABS database, which is the State Lands and Building System Inventory. That's a centralized database or inventory of title documents relative to the land holdings of 20 or so of the largest state agencies. And every year we prepare what we call the March 1st report that we submit to the legislature that summarizes these holdings. The Historical Records section also manages the state's historical tax tax adjudications. And these are adjudications to the state for non-payment of property taxes that occurred between 1880 and 1973. Prior to 1880, all adjudications were canceled, and after 1973, that responsibility was transferred to the parishes. We're the custodian of those old tax record books, and we assist abstractors and title attorneys with locating those records also. We also administer the process for cancellations and redemptions for some of those properties, and occasionally public auctions. And then we have the titles and surveys section. This is the section that I managed for about 4 years prior to becoming administrator. I first started with the land office in June of 2016 managing this section. In this section, we assist in determining the state's title and ownership claims to lands and water bottoms. We're often working with the Attorney General's Office, the Office of Mineral Resources, the Department of Wildlife and Fisheries, and other agencies and private individuals to investigate and resolve title disputes. We also manage a number of geographic information systems databases, which is basically a interactive digital mapping system similar to Google Earth where you can turn layers on and off. We manage the state's GIS database layer of state-claimed water bodies. We also manage a GIS layer for the slabs database and a GIS layer reflecting minerals from land sales where the state sold land and reserved minerals. This is all used by countless agencies, used heavily by the oil and gas sector for the state mineral leasing program. We have 2 field crews, land surveyors, engineering technicians, public land field officers, boats, trucks, and ATVs. The field crew also assists our last section, the land and water bottom management section. This is where the bulk of our revenue is generated. This section handles the permitting and leasing of encroachments, most often dealing with the bed and bottom of navigable waters. We administer things like permitting land reclamations to recover land lost to erosion, permitting bulkheads, piers, and wharves. We issue right-of-ways for pipelines and electrical lines across state waters and the rest of our property. We do recreational leases for houseboats and campsites. We do commercial leases also, everything from casinos and marinas to barge moorings and loading docks. House Bill 184, Representative Villio's bill, relative to the state leasing a portion of the Better Lake Pontchartrain to Jefferson Parish is one example. Our office is the agency that's working with Jefferson Parish on that. And lastly, the land and water bottom management section also handles the surplus property sales. The state land office is responsible for receiving surplus property transfers from agencies that no longer have a use for the property and wish to dispose of it to eliminate the cost associated with its ownership, the cost of management, insurance, and maintenance, and that sort of thing. Our office handles the marketing and sale of those properties, and those sales often become the subject of bills that come before this committee for approval. So that's it. That's a general overview. I wanted to keep it brief. I want to thank you all for the opportunity to come in and introduce myself and tell you a little bit about the office, and just want to say that I look forward to working with you all. If you all have any questions or anything that we might be able to help with, please don't hesitate to reach out.
Mr. Hill, what is your total budget on the self-generated revenue?
We operate on a budget of about $2.5 million, and we generate $5 to $6 million.
Well, we appreciate you coming today. We do recognize Representative Villio's bill that you mentioned earlier was one of the first ones we voted on this session. It's been making its way through the process, and several other land transfers that have come in through here. So we appreciate that, and we look forward to working with you.
Sure thing.
Okay.
Yeah, have a good day. Thanks.
Representative Kerner on a question. Mr. Hill.
Apologies.
Look, first of all, I want to thank you, Mr. Chairman. I want to thank you for working with Jefferson Parish, because I think that's going to be a wonderful project out there on the lakefront.
Yes, sir.
Maybe you can answer one thing for me, and there's areas where you can't fish because property owners actually own the waterway, and it eroded years ago, and so they actually are in control of those spots. But I just found it puzzling that a man that owns a lot in Lafitte, Barrett, Crown Point, anywhere along the coast, and he owns the waterfront in that area, but it also has eroded, say 50, 75 feet, but he has to pay the state a water bottom fee to use it. I just, and maybe you could answer at a different time, but I just...
Well, it depends on which route that he'd like to take. We do reclamations, and if it's within his title boundaries, then he has the right to reclaim his property, and he can pursue that, and that's without fee, and that returns him to surface and mineral ownership of that property. So if he doesn't wish to do a reclamation, again, reclamations are limited at the 1921 shoreline. So if he needs to go out beyond 1921, that's going to be a water bottom lease.
Yeah, I just find it funny that he'd actually have to pay a fee to park his boat on his property.
Yeah, that's pursuant to the Title 41 statutes and the admin code. So,
Representative Kerner, as much as you'd like to filibuster today, we need to move on.
All right. So. Okay.
all right. You're welcome.
Okay, so we're going to move on to our resolutions and bills. A couple of rules to start out the day. We're going to put a 5-minute rule in play, which means that the testimony of the rep or the senator will be limited to 5 minutes on introduction, 5 minutes on closing, and then each rep who has a question, I'll give you latitude of about 5 minutes. But once Senator Hewitt is done with her resolution and her Senate bill, Senator Feezy's bill is going to be split for the remaining time between the proponents and the opponents. So the 5-minute rule is going to be kind of a moving target, and we'll do our best to get everybody in here. We have a hard deadline of 10:30. So as I mentioned earlier, we're going to try to work with all the parties to get as much testimony as we can before that hard deadline hits, and get our votes in within that time frame as well. So, first up, I'm going to welcome Senator Hewitt to the table to speak on Senate Concurrent Resolution 7. Mr. Bosworth on the resolution.
Thank you, Mr. Chairman. Members, SCR 7 is a resolution to urge and request certain officials and local governments to dismiss coastal lawsuits.
Senator Hewitt on your resolution.
Thank you, Mr. Chairman, and thank you, members, for giving me the time this morning to talk to you about this. You know, many of you know my background. I started out on a drilling rig at a time in the early 80s when there really weren't very many women offshore. And my career progressed, where I was managing billions of dollars of assets and hundreds of employees. We did everything. We did the exploration work, we did the drilling work, we built platforms, facilities, laid pipelines. I've designed sucker rod pumps in West Texas and CO2 floods in Mississippi and gas-lifted wells in South Louisiana. It's been a very diverse, broad background. I've negotiated unitization agreements and joint operating agreements with major companies and landowners. And what I've learned from all of that is that oil and gas reservoirs do not know parish boundaries or state lines. They don't know leaseholds and offshore waters. The oil is where the oil is, and the gas is where the gas is. And so that's why offshore waters are managed by the federal government. And that's why onshore mineral revenues have to be managed by the state. Because there's an optimal place to drill a well. And you could lay out a map, a geologic map, and almost any geologist or any operator would choose to drill the well in almost the same place because of the geologic formation. And if you don't drill the well in that place, you're not going to adequately produce all of the oil and gas. So lots of the disputes end up being, if you have a leasehold and someone drills a well over here that harms the person on this side of the lease, you have issues. And so those are the kinds of things that the reason why you're going to leave oil in the ground if you don't drill the well in the right place, and if you don't find a way to share the reserves and the production in a fair way based on how much is on your property versus the other person's property. And that's true whether you're a landowner or whether you're an operator with onshore, offshore properties. It has to be that way. And so for me, it seems very clear to me why minerals are listed in our statute as being an issue of state concern. It has to be that way. It's the same reason we manage the coast and coastal restoration projects across the coast. It's the reason why we manage water issues across the coast, is because that's the only way to do it, where everyone's treated fairly and everything is being appropriately managed so that you're maximizing your resources. And so it seems very, very clear to me that you have to manage minerals at the state level. And so this resolution is kind of a restatement of that fact. And I believe that the lawsuits that are in place right now have had a chilling effect on the oil and gas industry. I talk to investors all the time that will say, don't show me a property in Louisiana because I don't want to get all hung up in all the lawsuits. And we know that's true. And now there are 30-something states where people can actually go invest and drill wells. You don't have to drill wells in Louisiana anymore. We also know the importance of this industry to both our state and to our country. And I've testified before Congress to that effect. It generates, as y'all know, most of the coastal restoration dollars in our state come from oil and gas interest. And so this resolution is basically urging and requesting the parishes to drop the coastal lawsuits for many of the reasons that I've just stated.
Thank you, Senator Hewitt. I have a question on the floor. Representative DeVilliers.
Thank you, Mr. Chairman. Senator Hewitt, first of all, thank you for bringing this resolution. I've mentioned many times before that my district and many districts throughout the state are struggling greatly because of what's going on in our oil and gas industry. Do you feel like, or can you specify maybe a few areas with your expertise and your experience in that industry? What are some of the main drivers that are, I guess, taking the oil and gas industry and the jobs that go with it away from our state?
Well, I certainly think the lawsuits are part of it. You know, that's managing part of your liability or your exposure. So if you have, if you are at risk, right, from a liability standpoint, or you could be at a future risk, you know, that certainly is going to encourage people to go invest their dollars elsewhere. You know, prices are about the same everywhere, the price of oil and gas. You know, so, you know, people are looking for ways where they can minimize their expenses and maximize their revenue. And so some of it clearly is geologic plays are going to, you know, be a factor in that. The Permian Basin has been exploding. Those are relatively cheap wells and with quick return on their investment. But we know that there's also the issue of liability. And so when people are looking to invest their dollars, they don't want to invest in Louisiana because between the legacy lawsuits and the coastal lawsuits, it's just a nightmare for them. And they have too many other options. So you're going to always have a list of opportunities where you can drill wells and where you can invest. And they have a limited amount of dollars. And so it's just easier for them to go someplace else.
Or our natural resources here, I guess specifically the oil and gas, I mean, are they lesser in value than they are in Texas, Oklahoma?
No, they're not. I mean, not every barrel of oil is the same. So some are, you know, sweeter or more sour and more expensive or cheaper to process, depending on, you know, what it is that you want to do with it. But no, ours is of the same value of as anybody else's. We have all the same opportunities. We've certainly had lots more drilling rigs in the past than we have right now. You know, so.
You had mentioned issues of state concerns. Is that something new? I mean, is that something that we already have basically in the law today?
No, I think it was in 1978, the Coastal Zone Management Act was put in place. And that basically established in statute the difference between issues of state concern and issues of local concern. And it clearly says, this is statute, and I know y'all are familiar with this, 49214.25. It clearly says all mineral activities, including exploration for and production of oil and gas and other minerals, are issues of state concern. And it seems so obvious to me and so logical that it should be that way. It talks about things that are, you know, state-owned lands or things that share more than one water body or things of a national or state or regional interest. And it's because those things would be too difficult to do otherwise. Issues of local concern are much smaller projects. It's jetties or breakwaters or bulkheads or piers, you know, things that are smaller projects, and they're going to be most likely located within one parish. And so those things make sense to me. And I just, again, I know that you cannot manage minerals that know no boundaries, no artificial boundaries. You cannot manage them on a local level because you're going to be competing against each other in ways that would be harmful to to the overall production of the state's natural resource.
Do you believe in legislative intent?
Well, of course, everything we do is legislative intent.
What do you feel the legislative intent was in 1978 when they brought about this law?
Well, it's certainly my interpretation that they were clearly trying to spell out the difference between state and local. And I think you can't read it any more clearly when it says all mineral activities, including exploration for and production of oil and gas. So I think that's very clearly an issue of state concern. And I think it needs to be managed at the state level.
So that would be my final question. As far as if there are issues that are brought forth today because of maybe some form of neglect or however it wants to be spelled out, we do have laws in place today that allow the state to go in and I guess go after the individuals who are making, I guess, the wrongdoing. And what agencies are tasked with that today?
It's the Department of Natural Resources under the Office of Conservation is responsible for issuing the permits and enforcing the permits, and then there's specifications in the law as to how any penalties or violations would be assessed and how those are calculated. And I think they have all the tools that they need to be able to enforce those permits and to do their work.
Okay, thank you. Thank you, Mr. Chairman.
Thank you, Representative DeVilliers. Members, we do have an amendment that we need to take up. Mr. Bosworth, on your amendment.
Thank you, Mr. Chairman. Members, the set of amendments before you is coded 2634 in the top right-hand corner, and it can be viewed online.
Members, this amendment is being submitted by Representative Landry, and we're going to give her an opportunity to explain that amendment. Representative Landry.
Good morning. I didn't bring my computer. I don't know if I can have a paper copy or something.
Sure, we'll get that to you.
I apologize. It's late.
Rep, you can proceed as we're getting her the paperwork.
Okay. It ends up being 6 amendments because of the different deletions and additions into it. And the sort of main thrust here is that I feel like this resolution is not an accurate representation of the litigation that's gone on for a long time. And the crux of it is it ignores 49 to 1436, which specifically does give legal authority to these suits. For the other people in this room who don't have this in front of them, this is a subsection of the provision that's referenced in her resolution. And it says that the Secretary, Attorney General, District Attorney, or local government with an approved program may bring injunctive, declaratory, or other actions to ensure that no uses are made of the coastal zone for which a coastal use permit has not been issued or which are not in accordance with the terms and conditions of a permit. So that is what the litigation that's been going on for years is about, is this particular paragraph. And as I'm sure you're aware, there have been numerous federal court judges and state court judges who held that this is applicable. In terms of the reasons for why this has gone on for a long time, it's because they just appealed the hell out of it. I watched some of it for years at my old firm, and this just went on forever. A lot of it was politics. A lot of it was trying to keep the matters in federal court. The arguments were tenuous at best. But I think to introduce a resolution that says that these suits were improperly brought is, first of all, incorrect. And also, that's up to a judge and a court to decide if a matter is legal or not. And these cases were not thrown out as being frivolous. They're still ongoing. Further, these are 6 different things. Like for one provision, for instance, it says over 6 years of litigation has provided no benefit for Louisiana's coastline. First, again, as I said, they've been kicking the can for years in appeals. So it's not like the plaintiffs weren't ready to get into discovery and settle. But also we have the $100 million Freeport settlement that is just sitting, waiting there to finish. So to say that there's no benefit is not actually accurate either.
Well, I don't think it really put any, a shovel full of dirt anywhere in terms of coastal restoration. Lawsuits are not generating any value in terms of restoring the coast.
Well, yet.
And you don't have a Freeport settlement either. We've already established that in earlier testimony.
It
And so
hasn't
all
happened because
parties-
of us, because of this,
No,
this building.
it's because not all the parties have signed the agreement. And until they do,
Right.
you don't have an agreement.
Well, they're hoping the legislature will kill it. But the money is there waiting to be discussed. And just all of this, it's just the fear is that this is going to be used and presented to a judge and that this will indicate that the legislature wants these suits killed when this is not actually a bill. This is just a resolution. And for it to have so many misrepresentations in it as to what the legal situation is concerns me, and that's why I have these amendments.
Rep, are there any other amendments that you want to explain in any detail, or does that cover it?
Well, for instance, Amendment 5 has the factual statement that a federal judge and 2 state court judges have held that parishes and district attorneys have the right to file suit under 49 to 1436 to enforce violations relating to state concern permits. That is a factual analysis of what has happened. And then Amendment 6 to insert that this resolution is not intended to be offered in evidence or filed in the record of any court in which suits filed by any parish pursuant to 214 are pending, as this is not actually evidence of anything. It's just an opinion piece for the most part.
Which is customary in a resolution.
Well, that's true, but this is, I mean, a multi-billion-dollar situation involving litigation that's gone on for 6 years, and it should reflect the actual reality of the lawsuits, and right now it doesn't.
I disagree with that. I don't think that it misrepresents anything at all, and I think that the court cases that you're referring to were more about do the cases belong in state or federal court, not whether people have a right to file suit.
I don't think I don't think I'd agree with that interpretation of those suits. Definitely jurisdiction was the main focus of them, but never has a court decided that the parishes don't have a right to bring the suit. And in particular, it does trouble me that the resolution doesn't reference 21436D, which is the crux of all of this, and it's pretty clear who has the right to bring these suits.
Yeah, I disagree with the amendments that you've presented. I certainly respect the
effort.
The effort, sure, and your interest in this topic.
Okay.
Thank you, Representative Landry. Members, the board is clear. We have an amendment on the table by Representative Landry. Do I hear an objection? Representative DeVilliers objects. Madam Secretary, please call the roll. Could you please explain the vote before we start? Mr. Bosworth?
Mr. Chairman, members, a vote yes is to add the amendments. A vote no is to not add the amendments.
Thank you, Mr. Bosworth. Madam Secretary, please call the roll.
Chairman Coussan?
No.
No. Vice Chairman Boryak? No. Representative Butler? No. Representative Carrier? No. Representative DeVilliers? No. Representative Desautel? No. Representative Kerner? Yes. Representative Landry? Yes. Representative Lyons? Yes. Representative Mincy? No. Representative Reiser? No. Representative Romero? No. Representative Wheat? No. 3 yeas and 10 nays.
Thank you, Madam Secretary. Members, there are no other amendments. The board is clear. Senator Hewitt, please close on your resolution.
I would just ask you all to support the resolution and allow this to move forward.
We do have some opposition. If you don't
Do I
mind,
get to close after the opposition?
you will be allowed to close after the opposition. Yes, ma'am.
Thank you.
We do have a lot of cards in opposition. Mr. Carmouche, would you like to come to the table? I'll let you quarterback the opposition. Mr. Carmouche, this is, I believe, this term, your first time before the committee. Please introduce yourself to the members.
John Carmouche, and I represent several parishes in the coastal litigation that's been going on for 8 years.
Before you start, just a reminder, we're on the resolution, and we will get to other bills that I know you're going to be testifying against, so just keep that in mind. Thank you.
And I'll try to rush through it because I know we've got a lot to talk about. I don't want to make it any clearer. This resolution will be used in the court. It will be used to beat up local politicians. It will be used in every race, no matter what it says. They spent $2 million in Plaquemines Parish beating up council members. They lost. So this resolution might, by law, be nothing, but this is a statement to the citizens of Louisiana that we don't care. In 2014, this body told the parishes who had already filed the suit in 2013 under Bobby Jindal, knowing that the claims were made on state concerns without the state involved, this body said, go forward. What's changed? So for 8 years, the parishes did what you told them to do. The only thing that's changed is they lost every hearing and every motion in every federal court and every state court. I'm going to get into the settlement in my other presentation, but it's wrong. It's wrong. And the paper, I think, says it all, where we stand in Louisiana and why we're in the position we're in. And why they can't win in court. Why did they come to this body? Because for 50 years, they got the same thing. Pass. Pass. You say, well, is the state concerned? Well, why hasn't the state enforced it? You know why? Because they come to this body. Every time they're losing, they come to this body and ask for a political bailout. It's happened. It's happened. And I think Louisiana's better than that. For example, East Timberlake Island. You know who had to pay for it? Citizens of Louisiana. You know how many oil wells were drilled? 700 oil wells. You know by whom? Chevron. You know what it cost the state taxpayers? CPRA taxpayers paid $800 million. Is that what we want to tell the federal government? We're not big enough and strong enough as a state to look people that do wrong and violate the law and say, pay for what you caused. We're going to turn the blind eye because of political pressure and make the citizens pay $800 million. There was 96,000 gallon oil spill, Chevron. They didn't pay anything. They actually Chevron built a wall in 1960 to protect their investment. And when they left, they left. Under the law, they were supposed to restore the property to its original condition. We turned a blind eye. We let the taxpayers pay. The only time it seems that they paid was a foundation paid $7.8 million that was given to them by BP and Transocean to settle a criminal case. Does that make us proud? So you're going to pass a resolution today to tell these parishes to kill the lawsuits? Because that's what this says. It doesn't say the state's going to go forward. It says dismiss the lawsuits. Dismiss the lawsuits. and tell the oil industry they have to do nothing, which we've done for 50 years. That's what this resolution does. And with all due respect to Senator Hewitt, I have to say it for my clients. I've said it before and I'll say it again. I think she's got a conflict. Her husband is an engineer in a company, and it's not a personal attack, it's a fact. Engineer with a company that's a defendant in 16 of these cases, who's a potential witness. But we're going to sit here today and pass a resolution and allow these oil companies. There's only 5 out of 843 operators today in the state of Louisiana. Less than 5% of defendants. You're not protecting the oil companies by dismissing these lawsuits who actually operate in this state. You're protecting the ones that left and don't come back. Because we haven't held them accountable. We've turned that blind eye. They're laughing. I want to see someone from Chevron, Shell, Exxon, Conoco. I want to see them show up today and tell you what they're going to do for you. Because they admit they caused it, over 30%. I hope they're here to tell you how they're going to contribute. Not by criminal, being forced to by criminal charges. I want them to tell you how they're going to take charge of this. Because they haven't done anything. For 8 years, there's no discussion of merit. They admit they did wrong. They just asking you, the state of Louisiana, because that's what's here. The vote today is for the state. It's not your individual vote. You're voting for the state of Louisiana and future generations. To look these companies in the eye and say you did what's wrong, and we're only asking you to pay for what you did. Thank you.
Mr. Carmouche, quick question for you. Actually, there's a couple of questions on the board. You had mentioned that the state hasn't filed any lawsuits, but just a point of clarity, is the state a plaintiff in the lawsuit currently? Have they intervened?
The state intervened. What I was telling you is over the last 50 years before the parish was filed, they have not filed a lawsuit.
Just clarifying for the committee that the state has intervened.
They have intervened, and actually I think it's an important point that they have joined in every motion that the parish has filed. They have never objected, not one time. The Attorney General or DNR has not objected one time to anything the parishes have done in 8 years.
Mr. DeVilliers, I have a question.
Thank you, Mr. Chairman. Mr. Cormouche?
Yes, sir.
Okay. I've never met you before,
No.
but I've heard your name a few times, so it's nice to meet you,
Nice to
I
meet
guess. Just so you know, I'm not an attorney, so you can have as much fun with me as you want. How long has the Louisiana Coastal Program been in effect?
Since 1978.
Okay, and since 1978, other than the lawsuits that you have filed, which have been about how long ago?
8 years, 7 years.
Were there any other lawsuits filed by a parish in the same type of situation?
No. There also has never been, we have a self-reporting process. So 95% of the lawsuit are actually permits that were not obtained. So neither the state, since 1978, nor the parishes knew because they were supposed to come get a permit and they didn't get it. So this is the first time in the history of Louisiana, that someone has actually stood up and said, do what's right.
Did you say that they actually didn't know? Did I hear you say that?
I could tell you that I have documents.
It's not a I got
Well,
you or something.
Look,
did you
you're
say
gonna have
they
to ask.
didn't
You're
know?
gonna have to ask DNR. But
Okay,
I can tell you there's a self-reporting process, and I've looked through every permit, and 99%, 95% of the permits were not obtained. So
it sounds like quite possibly that the state may have not been doing its job. In a sense, from what I'm hearing from you, is it possible that you can be hired as an attorney for the state versus for the parish?
Well, first let me answer the statement you
Yes,
said
sir.
first. state's not doing its job. The state is not doing its job because of why we're here.
I understand what your point is. I'm
that-
just hearing what you're saying.
Well, I understand, but I think we need to look at history, and we need to look at who were the Office of Conservation Commissioners. Retirees from Exxon, retirees from Amoco. Politics has played a role in this enforcement agencies forever, and it's changed. It's changed. So can I work for the state? I guess if I was hired by the state, but I
If
was
some of
hired
you
by the
could-
parishes.
Okay, well, on the parish side, how many parishes are involved? Not so much that have hired you, but how much are involved with the coastal zone? Is there 12?
I mean, well, there's 12 that the coastal zone was enlarged in 2012, but there's actually 12 parishes that would have the rights under the 1978 Act. Correct.
Okay, and out of the 12, I looked at, I guess, some of your contracts. How many have actually hired your firm along with other firms to defend them, or not to defend them, but I guess
To look at the damage
Yes,
model, I think all
it looked like there was 6.
no 6 have filed lawsuits. I think all 12. To be honest with you, maybe 11.
They've
but-
all hired. So all
hired lawyers. Correct.
Okay, and 6 have agreed to I guess a tentative type settlement.
6 have filed a lawsuit.
Okay.
What happened was after the lawsuits were filed, there was a new attorney general who came in and told all the parishes to hire lawyers because the lawsuit's going to proceed. He intervened and told them, don't hire a lawyer, don't file a lawsuit, because at the end of the day, there's going to be a damage model that's going to be, we're going to come to you and ask you about, because there's going to be a settlement. So what's happening right now, I have 6 signatures who have signed the settlement. Just like any other litigation, this is not unusual.
Mr. Carmouche, actually, Representative DeVilliers, in the interest of time, I'm going to take one more question.
I'm just, and I respect that, Mr. Chairman. I'm just trying to understand the process of the lawsuits, the settlement, and the if there's 12, I guess, parishes involved, but only 6 have signed on. How does that affect the actual settlement? I mean, if they're not all agreeing to sign on,
That's not true. Nobody,
I thought you
because
just
a parish president says he's not going to sign. With all due respect, that doesn't mean that the parish can't sign. In one instance, the council actually hired the lawyers to do the investigation. So there's certain entities in the parish. So just because some parish president comes and says, look, we're not signing, that doesn't mean the DA can't sign. That actually doesn't mean the state can't sign for them. And if the state signs for them, you know what they get? So I promise you, we go down to those parishes and we say, look, you can sign and receive your benefit, because they sat back. We told them to. We said, don't file a lawsuit. Reap the benefits. But if we go there and they say, we don't want anything, okay, well, the governor can sign for them.
Yeah.
That doesn't mean the settlement's not going to go through.
so I do appreciate you explaining so I can better understand, what it is that you're trying to accomplish. Thank you, Mr.
Thank you,
Chairman.
Representative DeVilliers. Representative Landry, very quickly, and then we're going to read in cards in opposition, and then we're going to read in our cards in favor, and we're going to move to closing. We're going to finish all of that within the next 4 minutes, and I'm pretty serious.
Okay, I'll get to the point. All these years of litigation, obviously most of it has involved jurisdiction, which court they're going to be in. But can you talk a little bit more about what I touched on with Senator Hewitt about what the court found in terms of the properness of the suits?
So there has been a challenge by the oil companies, both in federal court and state court, if the parishes have the right to bring the lawsuit under the 1978 Act, and all judges have said they do.
Thank you.
Thank you, Mr. Carmouche. Senator Hewitt, you could return to the table. I'm going to read in cards in opposition. In the interest of time, I think every one of them said that they are opposed but do not wish to speak. A couple of them are blank to that effect. John Carmouche, Isaac Jackson Jr., Donnie Robin and Associates, maybe Robin, Richie Hike, Benny Roussel, Plaquemine Parish, Parish President Guy McInnis, St. Bernard Parish. Parish President Cynthia Lee Shang, Jefferson Parish. Councilman at Large Ricky Template, Jefferson Parish. Dan Robin Jr., Robin and Associates. Mayor Tim Kerner Jr., representing Lafitte. Jennifer Ansardi, representing Jefferson Parish. And Victor Marcello, who also submitted a statement online that was distributed to the members. Cards in support of the bill: Chris McClendon, representing himself. Josh Burrell, representing Chevron. Donald Price submitted a white card from the DNR, willing to provide information. Gifford Briggs, Loga, Tyler Gray, Lamoga, Robert Bauman, ConocoPhillips, Mark Earhart, Grow Louisiana Coalition, Renee Amar, Pelican Institute, Neil Buckingham, Shell, Keely Miller, Infrastructure and Policy Initiatives, and Mark Earhart, Grow Louisiana Coalition. So those are all of our cards. Senator Hewitt, on your closing.
Thank you, Mr. Chairman, and thank you, members, for your time this morning. I want to start out by addressing, of course, the inappropriate comment that Mr. Carmouche made relative to my husband and his employment in the oil and gas industry. That absolutely has nothing to do with this, right? Many of us have family members that work in the oil and gas industry. His experience is 100% in deep water. He works for a company with hundreds of employees. It's a privately owned company. He has no interest whatsoever, and his compensation will not be affected whatsoever as to whether these lawsuits go forward or not, or they're successful or not. And so I take offense to him continuing to bring that up. And you all are all employed in different industries. And to try to imply that you cannot talk about or bring a bill in an industry in which you have professional experience is insulting. And that is what our representative government is all about. We depend on you to bring bills in areas where you have expertise and a professional background. And so I respect the work that you do, and I hope that you respect the work that I've done. It's been a few years now since I did that. But I think that's a smear technique. It is what he's done through this entire conversation. Much of what he said I disagree with, and I think he misrepresents it dramatically. The issue of state concern has been confirmed by the intent of that, and the Coastal Zone Management Act in 1978 has recently been reaffirmed by Congressman Coussan, who wrote the bill. We have a letter from NOAA, the National Oceanic Atmospheric Administration, right, that reconfirmed that our policies and our things are in terms of how state use and local use is defined is clear. When he talks about the permits, and most of the lawsuits have to do with permits that were not filed, it's because they weren't required to be filed before 1978. It wasn't because anybody was not doing what they were supposed to do. And there's been testimony in the past that for those permits that were filed, they didn't find any violations. DNR's been through that. They've testified to that. There haven't been any violations for those permits that were filed. This is all about overreach. This resolution, again, is an urgent request. My parish presidents know my position on this, and we've been talking about this since we were elected in 2016. I just respectfully disagree and believe that, again, that mineral rights are clearly defined in statute as being issues of state concern. From a geologic standpoint, there's no way it could be done any other way, in my opinion. And so this resolution is simply urging and requesting that they drop the coastal lawsuits.
Thank you, Senator, and I couldn't agree with you more. To talk about what each one of us does for a living, much less our spouses, is out of bounds, in our capital. And I just think that's some decorum that we're all learning as we go through this process, especially the 10 new members that we have on this committee. Appreciate you commenting on that. The board is clear. Do I have a motion? See a motion from Representative DeVilliers to move the resolution favorably. Do I hear an objection? Have an objection by Representative Landry. Madam Secretary, will you call the roll? Yes.
Vice Chairman Bouryak? Yes. Representative Butler? Yes. Representative Carrier? Yes. Representative DeVilliers? Yes. Representative Desautel? Yes. Representative Kerner? No. Representative Landry? No. Representative Lyons? No. Representative Mincy? Yes. Representative Reiser? Yes. Representative Romero? Yes. Representative Wheat? Yes. 10 yes, 3 no.
Thank you, Madam Secretary. And the bill moves favorably, this resolution. Thank you. Senator, we're going to move on to your next, which is a bill, Senate Bill 353, provides for, environmental control. Mr. Bosworth on the bill.
Thank you, Mr. Chairman. Members, Senate Bill 353 provides for carbon sequestration.
Senator Hewitt on your bill.
Thank you, Mr. Chairman. Members, this is a great bill, in my opinion, in that it helps the environment. Carbon sequestration is the process by which you capture carbon in the air that could be emitted, let's say, at a refinery or a manufacturing facility. You'll capture the carbon from the air, inject it into a pipeline. We have a tremendous infrastructure of pipelines in the state of Louisiana. Transport it to a place that's got a depleted oil and gas reservoir and inject it in the ground for storage. In some cases, it could be resold at a future date for an enhanced oil recovery project. They do a lot of that in Mississippi. I've been part of those in the past. So it's a win-win. It takes advantage of our current infrastructure. It cleans the environment. It's a great business opportunity. And Louisiana is well positioned to be a leader in carbon sequestration. There's some federal tax credits right now that are available. And so what this bill does is it basically is establishing a framework to allow us to take advantage of this opportunity. And we've had tremendous interest from many, many businesses on this bill. There's still work to be done to kind of keep putting, I'm going to say, more meat on the bones to further develop this opportunity. But we have a framework right now that everyone has agreed to, and we're ready to move forward. We've worked closely with the department and industry, and I think everybody's on board.
Thank you, Senator Hewitt. We do have a question, Representative Bouryak.
Thank you, Mr. Chairman. Senator, I first wanted to appreciate you allowing the company in my district to work with you last week when you came, give them a little more time to review the bill. So I do appreciate you being patient. And at the appropriate time, I think this will help a lot of companies in the state, especially in District 47. So at the appropriate time, I move favorable.
Thank you, Representative Bouryak. Not quite the appropriate time. Representative Mincy on your question.
Yes, Senator, thank you. And I've got a couple questions. I'll try to make it quick.
Okay.
Removing of the pipelines from what can you explain that, elaborate on that for me?
Yeah, I think we spent a lot of time sort of trying to debate that. The issue is trying to define the scope of what is a storage facility. And so we defined a storage facility as I'm going to say sort of the end of the line where you're actually injecting the CO2 in the ground. Pipelines are generally not part nor the source of the CO2 where it's captured. They're not normally defined as part of that. And the reason for the clarification is just there's other things that are already guiding pipelines, lots of statutes and laws and what have you directing that. This is about the carbon storage and the liability related to that, et cetera.
Okay.
So it's not to say that they're not important. They're just defined elsewhere and how that's handled.
So it does have an impact on the liability of the pipelines,
Yeah, pipeline liability is already handled someplace else. This is talking about the liability, could be, 50-year liability right now for carbon storage.
Okay, and if you could, the Carbon Dioxide Geological Storage Trust Fund, what does that, new to the committee, but new to the subject, what does that actually do?
Yeah, I think that has been in place for a long time. That's a dedicated fund we haven't really ever used. It's there in place. I don't think it has any funding in it whatsoever, but I believe the intent would be for it to be kind of like financial security for orphan wells. There will be a funding mechanism where there will be money put aside to do any environmental work or abandonment work required at the end.
Okay. And my last question, the formula that was used, it was just kind of unique. Do you have any, can you give me any elaboration on how that formula was come up with?
I cannot. I did not develop the formula, but I think it was. I cannot honestly tell you how that formula was developed. It was intended to have payments over a certain number of years, obviously, as a funding mechanism. And I don't know. I've got a gentleman here that's worked with this. Maybe I'll invite Greg to come to the table and see if he can comment on that for you.
Yeah, just on it could have appear arbitrary, but I know there's a method to the madness. So if you could just briefly.
Sir, have you submitted a white card?
A green card, sir.
Oh, so you did submit a green card. Okay, please introduce yourself to the committee.
Thank you, Mr. Chairman, members of the committee. I'm Greg Schnocky. I'm Executive Director of Government Relations for Denbury Resources. We're a CO2 pipeline operator here in Louisiana and oil and gas operator. We're headquartered in Plano, Texas, and we operate about 275 miles of CO2 pipeline here in the state. To answer your question, that's a good question. We're still in some discussion with the department with regard to this formula and how it would work going forward. This all came from a request from the department to engage in the discussion about how CO2 storage operations could operate in the state, and this bill was a result of that. So there are certain questions that we've parked, I guess, for some more discussion with the department. This is one of them with the formula, because we're not completely clear how that funding mechanism would work, but I think we're all in agreement there will be some sort of funding for, as the senator pointed out, protection of the environment in terms of how the a storage facility would operate. So we're still grappling with this. This was done in 2009. I think there was a rush of a number of these types of bills around the country. A lot of things have changed in the United States since 2009, and so again with the tax credits and other types of things that have come forward, there's a lot of discussion now about how this would actually be implemented and operate. And I think we'll continue that over the next year with the department. We may be back in front of you next year with some additional discussion.
Okay. Thank you. No further questions.
Thank you, Representative Mincy. We do have somebody here from the Department of Natural Resources. If they'd like to make a brief comment on the issue, we have Blake Canfield here willing to provide information. Also, Jason Lonclose willing to provide information.
Thank you, Blake Canfield, Department of Natural Resources. So as was stated, we have been speaking with Denbury and Senator Hewitt regarding changes that they'd like to see in this 2009 Act. The formula, for instance, I think had set it up of being paid out over a 10-year period, and it's now being changed to 12 years. But again, it's something we're going to probably have to come back towards as we get a better handle on exactly what all is going to be involved. My understanding was that the 12 years more aligned with the type of funding that and or loans that could be garnered by the industry. So that was sort of some of the logic, I think, on that change. But in general, the state is very supportive of trying to promote CO2 sequestration, and we think we are very good, have very good both geology, infrastructure, and expertise within the state. Happy to answer any questions.
Thank you, Mr. Canfield. The board is clear. Members, the board is clear. There's no proposed amendments. I'm going to read the cards in support from Mr. Greg Schnocky, who just spoke, Tyler Gray with Lamoga, Gifford Briggs with Loga, Neil Buckingham with Shell, and I do have one card in opposition from Margie Vickner Prey with the Sierra Club Delta chapter. Okay, Senator Hewitt, Representative Lyons had a question but wasn't able to press the board. If you don't mind, would you take a question?
Absolutely.
Representative Lyons, on your question.
Yes, as I look at this and I was listening to Representative Borak's response and all to it, I just have one question about eminent domain. Can you kind of explain to me, how it works, or just the aspect of it in the bill?
I'm not sure that I can. But I'll see if Mr. Gregg would like to come comment on that. Specifically, are you looking at a specific area, Representative, in the bill?
No, just in general.
In general, okay.
Yes, Mr. Chairman, Representative, the eminent domain provisions of this particular area of the statute are really unchanged. What was done as a technical matter was that the eminent domain aspects of this particular title were moved to another area of the code where the eminent domain authority rests for other types of activities. And so, in general, there is authority for eminent domain for CO2 pipelines in general, but this storage element, when we removed CO2 pipelines from the storage aspects of this particular title of this particular area of the code, we just moved the eminent domain piece to the other more general area of the code as a technical matter. So nothing has changed from current law today, if that's a part of your question.
That was my question. I wanted to know how current law, what would the change would be in that aspect? Okay.
No change whatsoever.
All right. Thank you.
Thank you, Representative.
Thank you, Representative Lyons. The board is clear. Senator, could you close on your bill?
I would just ask that you all move favorable on this bill. I think it's a great opportunity for our state. It's going to be good for the environment, and I'm looking forward to continue to work on this opportunity.
Thank you, Senator. Do I have a motion? Well, I see Representative Boryak move favorably. Are there any objections? Hearing no objections, Senate Bill 353 moves favorably. Thank you, Senator.
Thank you, Chairman. Thank you, members.
Members, it is 9:30. We're due out of the room by 10:30. I know we heard a lot of comments that probably could apply to the remaining issues on the table. So we're going to continue to watch our time. And next up, we're going to hear Senator Fazy. We have Senator Fazy on Senate Bill 440. Mr. Bosworth, please read the bill in.
Thank you, Mr. Chairman. Members, Senate Bill 440 provides for enforcement of the Coastal Zone Management Program.
Senator Fazy on your bill.
Thank you, Chairman and members. Each of us bring a unique perspective to the legislature. All my life I have worked hard to create jobs and build a good business, and that's why I'm here today. I was born and raised in Terrebonne Parish, and at that time, it was the largest landmass parish in the state. But after 100 years of the mighty Mississippi being blockaded, we're now the smallest by far. Terrebonne and Lafourche Parish were built by the silt of the mighty Mississippi. So my cause is to get Bill 440 into law to help bring all the coast back. 440 ensures every penny recovered, whether through fines or settlements, whether by the state or parishes, that every single penny goes to coastal restoration. Without 440, there are gaps. A lack of governance that could be significant and could see money for our coast siphoned off into other areas and other projects. We've worked hard for decades to build a state system of coastal management. Restoration projects are being led by some of the smartest people we have on staff, and progress is being made. Just as we've made progress in our coastal plan, we must continue to make progress in our laws. And that is where 440 comes in. It is simply updates the law to create buckets that ensure every dollar that should go to coastal restoration actually goes to coastal restoration. Under 440, the public will know with confidence that the coast will be protected. Under current law, which I believe needs to be improved, it assumes that there are only one source of money, the state, and there are 3 buckets for the money to be placed in. J currently holds the 3 buckets: Coastal Resource Trust Fund, Wetlands Conservation and Restoration Fund, and a local mitigation bank which has never been created by the parishes. But under 440, what we do is break the monies apart, because you have fines and you could have settlements. So under the fines, we deposit the money in the 3 buckets: 25% in the parish restricted fund, 25% in coastal protection and restoration fund, and 50% in the coastal resources trust fund. Under 440, under the settlements, it is 25% is deposited in the parish restricted fund. But then we add a little more for the parishes by adding 25% to a restoration fund to be matched by local government to give them more money. And then 50% to coastal protection and restoration fund. And what this does is ties all the money into our master plan that is run by CPRA, which helps build the coast as a team. If we get each parish doing its own thing, we're not going to have any consistency, and all the money is going to go to waste. 440 recognizes the difference between state and local concern. This is important because without 440, we cannot ensure that the money collected by locals goes 100% to coastal restoration efforts. 440 clarifies this point and protects every single penny. 440 also involves the parish's coastal restoration efforts by filling the gap created when locals didn't create mitigation banks. And its incentives them to participate even more with the matching funds. 440 also ensures that the work and progress made under Coastal Master Plan is protected. Every parish participates and the priorities laid out on the Coastal Master Plan are still followed. 440 ensures that the money goes to where the impact occurred. So basically what 440 does, overall, make sure that the money is spent under the master plan to make sure all parishes are protected.
Senator Fazy, thank you for that explanation. Senate Bill 440, so in its current posture, is a settlement bill, correct?
It's basically to make sure fines and settlements are put in the right buckets.
We have an amendment on the table, and what I'd like to do is take up the amendment so that the rest of the discussion can cover both your bill and the amendment.
Okay.
And I think everybody will follow it from there. Mr. Bosworth, could you read in the amendment?
Thank you, Mr. Chairman. Members, the amendment set before you is coded 2600 in the top right-hand corner, and there are 2 technical corrections that we need to make to this set of amendments. In amendments 1 and 2, so on lines 2 and 4, we need to make a technical correction to change the statutory reference to subsections C and D to subsections D and E.
And that's the technical aspect. You want to just read in the substantive part as well? Or we're going to take them up. We're going to take them up all at the end. This will just be handled upstairs. I understand, but we're going to read in his amendment as well.
That's it. So you can take it.
Okay. Representative DeVilliers, on your amendment.
Thank you, Mr. Chairman. Senator Fessy, am I saying that proper?
Fazy, actually.
Fazy, okay. Big Mike.
That'll work.
I remember seeing those signs going down to your area one time, so kind of stuck with me. Would you agree that everyone here cares greatly about the state of Louisiana?
Definitely.
Okay. I would agree with that statement. And I want to thank you, first of all, for bringing your Senate bill today. I know that it is an important piece of trying to fix things that are going on in your area. Senator, I have expressed in the past from visiting with my constituents about the situation we're facing with jobs in our state. And I've spent probably the last 4 years visiting with different businesses and groups and trying to understand what I can do as a legislator to try to help bring the jobs back to the state of Louisiana. And most of these jobs are created around our oil and gas industry. Are you hearing those same concerns in your district?
Very much so.
Okay, Senator, would you agree that the oil and gas industry has some of the highest paying jobs in the state, and that the loss of these jobs, as well as the reduction in production of the natural resources, will continue to make paying for our government services more difficult?
I totally agree. In fact, the way things are going, I can almost imagine every other house and every subdivision in our area being for sale if this keeps going.
I see that in my district as well. Senator, in 2016, my first year here, we were faced and actually did cut tops by $70+ million. We were faced with cutting K through 12 education. We were faced with cuts to healthcare, infrastructure, and those types of things. And the reason I bring that up is because I feel like if we don't do something to recreate our tax base here, we're just going to continue to go down that path. Senator and members, one of the bills I filed this session to address some of the instability that's crippling our oil and gas industry mirrored Senate Bill 359 by Senator Hinskins. I would like to offer an amendment that will incorporate some of the same principles that Senate Bill 440 does. As you know, the State and Local Coastal Resource Management Act passed by the legislature in 1978 drew clear lines of distinction over certain uses across the coastal zone. There are uses of state concern that Louisiana government has the right to regulate and enforce, and there are uses of local concern that local parishes have the right to regulate and enforce. In the state concern column are projects that cross multiple bodies of water and parish lines. These projects are specifically designated as uses of state concern. Specifically spelled out as uses of state concern, pipeline for transmitting oil and gas energy facilities and all mineral activities. Also clearly spelled out are uses of local concern. Examples include things like jetties, bulkheads, piers, small structures of less than 15,000, and I can go on. My amendments are intended to address the issues in a way that fully supports and complements Senate Bill 440. These amendments clarify and reaffirm that the state is solely responsible for permitting and enforcing uses of state concern across the coastal zone. Enforcement is the sole responsibility of the state. That means that the governor, through the Department of Natural Resources, or the Attorney General, are responsible for that. Thank you, Mr. Chairman and members. I'm sorry I went so long on just trying to explain why I feel like this amendment is important. Thank you.
Thank you, Representative DeVilliers. So, members and guests, what we have on the table is a motion to adopt amendment number 2600. What we're going to do is we're going to take testimony in favor of and in opposition to not only the amendment but the underlying bill as well, all at the same time. And I understand that each one of these cards in favor and in support would like to speak on both of those issues. So we're going to table the amendment vote until we conclude with all of our testimony. We have our first question, Representative Landry.
This question is for the chairman. My understanding is that this amendment would essentially add SB, was it 359 on it, which had a substantial fiscal note. And so I would ask that a fiscal note be requested for this amendment, since the cost to the state, if this passes, will be substantial. And I believe there's someone here to testify to the projected cost to the state. I think it's $4.3 million a case, and there's, forgot by now, 40 cases, something like that.
Representative, I'm gonna do a little bit more research on that. So we're gonna hear some more testimony while we do it. Thank you. Representative Boryak, on your question.
Thank you, Mr. Chairman. And just to be clear, this is on 440 as it in its current posture, correct? We're not entertaining the amendment just yet. Okay. Well, my question is specifically to 440. Thank you, Senator Fazy. I can appreciate your efforts in coming from a coastal area. I have 3 daughters of my own, and they're the 6th generation of my family to live in Grand Chenier. And in fact, we just moved a little bit to the north. So I do appreciate your efforts, and I do think after reading the existing legislation, you can see that there have been improvements made. You referenced the mitigation banks, completely understand that. And I do think the CPRA, even though we have some hiccups with them from a local perspective from time to time, they've worked with the locals quite well in recent times. But my question is, what parishes could apply for the 50% bucket? So if for the settlement,
basically, if I can get it to you correctly, the 50% is going to be put in a fund where it goes to the master plan. And so if we get involved with the master plan, if every parish which has getting involved with the master plan, that those monies would be put for projects in your area or whatever parish is in most need, and wherever the money comes from. Because mainly the money's set up to go to whatever the need is.
So I have that understanding for the 25% buckets, but for the 50% bucket, it seems to be just a little more general. And so my question is, if there's damages, or let's get away from that, there's a fine, okay? That 50% fine that goes into that bucket, if that was in a parish in southeast Louisiana, is there a process by which, in this bill, a parish in southwest Louisiana can go and get that money and put a project in their area for a fine that was generated in the other end of the state?
Representative Boryak, if I may, as I understand it, we're talking about the fine section of J1. Gifford Briggs, President, Louisiana Oil and Gas Association. So the fine section of it, the 50% of that money goes to reimburse the Department of Natural Resources for enforcing the provision. So there would be that's not related to the parish. If you got down into the settlement and judgments portion, that's when you get into the coastal master plan and other buckets.
So let's shift to that. Is the question still relevant to the settlement aspect?
So,
and I apologize for getting it backwards.
Sure. So as I understand Senate Bill 440 and the 50% bucket, that money is placed in the Coastal Protection and Restoration Fund to be used for projects as directed by CPRA for coastal master plan projects. So that money may be spent in a specific parish, or it may be spent in another parish across the coast. As I know you know very well, the coastal master plan is designed to protect the entire coast and not a specific parish.
Correct. Not isolated.
Correct.
And I think what I'm concerned about, we had a movement in years past to look at mitigation banks, because mitigation banks didn't have a piecemeal approach to restoration. But sometimes when there's not a mitigation bank in the parish where those damages occur, we're buying credits in other parishes. So I'm just concerned about, can we make sure or work with the CPRA as best we can? Is there a way to do that in this bill? I don't know that. To kind of protect those funds and make sure they're going in the areas of damage. And that's just
and basically that's comment. What we're trying to do.
Okay.
So I'm sure that we're getting with CPRA with all the different coastal areas that we can bring out and find out what's of most concern to make sure that we can save our coast overall as a team effort.
Are these funds sweepable? Can someone when we come back to this legislature at a later date, are any percent of those funds eligible to be swept to use for anything else? Another line item in the CPRA, another line item for Mesa?
So Representative Boryak, I'm not an expert in state budgeting, but I do understand from looking at funds like the Oilfield Site Restoration Fund that from time to time, up to 5% of those funds can be swept for state government, and that's rules that have been put in place by the Louisiana legislature.
Okay.
Whether these funds apply to that I don't know.
Got it. Okay. Thank you, Mr. Chairman.
Thank you. Thank you, Mr. Vice Chairman. Representative Kerner, on your question.
Thank you, Mr. Chairman. Thank you, Senator.
Okay.
In your bill, you talk about putting some monies towards CPRA, and they would administer and open up a restricted fund. And did you talk to anybody with CPRA? Because there's going to be cost to administer those projects, and also to have control of it and maybe do some matching money or whatever. Did you talk to them?
Yeah, basically, where we're going with that is that, once, say a parish has a project that they're really interested in and they want to put up matching funds, then they would put that 25% in with it, that extra 25%.
Okay, but in your bill, you state CPRA is going to open up a restricted fund, and they're going to administer the projects. I was just asking, if did CPRA agree to that? Did they say they're going to put up money to do those things? Did anybody talk to CPRA?
So I can't speak for Senator Fazy for talking to CPRA, but the restricted funds are set up by the local parish governing authorities through rules and procedures that are established by CPRA to provide the matching funds.
Okay, but do they? You still didn't answer the question. But do they? They're still going to administer their funds. So did anybody talk to them about putting up the money to do so? And then the restricted funds clearly says CPRA. Open up.
Let's see what it says.
Representative Kerner, as I look at section J3A2I, it says the restricted funds shall be administered by the parish governing authority.
Okay, let's see what we got.
And the rest shall be, in triple I, 25% shall be placed in the Coastal Protection and Restoration Fund used to match local projects selected by the parish and governing authority. So in that case, if Jefferson Parish had a project that they selected, they could use to match with funds administered by CPRA.
Okay, so we are saying that CPRA is going to administer it, but it's not going to cost them any money, so I don't get it. Jefferson Parish is going to actually put they're going to open up an account. They're going to be in control of the funds. CPRA is going to administer it. That's what we say. Or any parish.
I'd have to go back and read this again, but it says that for CPRA and the Coastal Protection and Restoration Fund, that they shall promulgate rules and regulations in accordance with the Administrative Procedure Act to provide submission and approval of plans.
Right. So what I'm saying is, anybody talk to CPRA, because that's going to cost some money. You familiar? I know, Senator. When you do projects worth multi-billions of dollars, it's going to cost you some money to administer those plans and overlook them.
Representative Kerner, I have a green card from Tyler Gray with Lamoga, who's here and willing to speak, and I think he has comment on the issue.
Yes, thank you, Chair. Tyler Gray, Louisiana Mid-Continent Oil and Gas Association. To answer your question, the Coastal Protection Trust Fund is a currently existing fund. It's not a new fund, so the restricted account would just be money taken from this situation. It's just adding to the bank account. There's no changes to the administration of it.
But still, that hasn't answered my question. The administrative fee, did anybody talk to CPRA? We got it in the bill, and did anybody talk to them? Are they willing to administer these?
I can testify to the fact that when that Senator Alon said during committee when he amended Senate Bill 440 to add this, that he did talk to CPRA.
Yes.
And they agreed to do the fund. Okay, so let me get to another one. You say local parishes can participate dollar to dollar for local coastal restoration projects, right?
Mm-hmm.
Do we know of any parishes that has the money to actually do coastal restoration projects? And we're talking about millions of dollars worth of coastal restoration projects. Do we know of any parish that actually has millions of dollars to put into coastal restoration projects, dollar for dollar?
Well, basically, it's an option. If I'm sure if a parish doesn't have any money, but we just want to make that available.
Yeah, and there's a couple things. When you say preferential treatment for local governments, even in your for local contractors in the bill, you might want to actually see if that's constitutional also, because I don't think it is. But I mean, I'm not a lawyer, but I mean that part of the bill too is I have problems with. But I will tell you this, that we talked about Terrebonne Parish in the fact that you think the sediment from the river has about building levees has hurt your area. Well, I could tell you, in my area, it's nothing but drainage canals going to all wells, all over, cut it up. And we suffered 18 times the last 29 years with tropical storms and hurricanes. And I think a large percentage of that is due to the oil fields.
Well, I have to personally disagree. I think if the river was flowing where it was supposed to be, all those would be filled up with silt.
Yeah, right. But then again, I think if the oil companies were to come there, they would still be filled up with silt.
Representative Kerner, you have a question?
Yeah, that's my question. Well, just one more. I'll end with you, Senator. I thank you for coming again. But do you think the fact that 95% of these oil companies are gone and they're working out of state, out of the country somewhere, we only have 5% left, right? Do you think it's fair for us to go to Congress and ask for taxpayers' dollars to fix the coast when we're actually letting the 95% that's actually doing business in other states and around the country go and they actually did the damage?
Basically, my bill is basically to set up where the money's spent. It's nothing to do with the lawsuits. It's basically where the money's spent. Now, as far as my opinion is, I think that when we levied the Mississippi River off in 1920, it caused devastation effect on the coast. And if you look up the records and study like I have on what the river has done by not feeding Bayou Lafourche and all the bayous down Terrebonne and all the bayous on the east side of the river, if you look at that and study that, we'd have had enough silt to actually build more parishes probably. But by letting it dump off in the end of the river, into the Gulf, into a big canyon, all the land is just washing away.
And Senator, I agree with you in a lot of that. But I will tell you, my family was first elected in 1888. I'm 60 years old. I've saw a lot of it, and I've dealt a lot of it. 2 shoulder surgery since, 2 hernias since. I've fought those hurricanes, and I know it causes to have a more of a negative impact than we normally would have had. But I thank you for your time.
Thank you.
Thank you, Representative Kerner. I have a question by Representative Lyons.
Thank you, Mr. Chairman. Now, I have one question for you, Mr. Chairman. Is someone from CPRA here?
I don't have a white card from CPRA, but we can. I'll give them a second if anybody runs in here.
That's one of the portions, and I'm going to start, Senator. As we look at this piece, and I can appreciate your history and your approach at this, but my biggest question is, of the percentages that you have in the bill, as it pertains to mitigation now with CPRA, I want to know from them what processes are they using to make those determinations. I know you have distinctive parts set aside in what local governments as a percentage that they can have, and I do appreciate the representative's question earlier about a government in one part of the state versus another government in another part of the state, I guess doing some type of cost sharing with this fund as it pertains. But I want to know from the CPRA right now, today, what's in place under the master plan to address those same issues. Is this the gentleman here? He's his master. I didn't recognize him.
Yeah.
Sorry.
I'm David Peterson. I'm general counsel for CPRA. And could you give me the question again?
The question
please?
is, as it relates to 440. I'm trying to stay on 440.
Yes, sir.
As it pertains to the CPRA and the master plan now, what this bill is attempting to address, in that, I'm assuming it's the mitigation properties along the coast as we are. What's in place right now to handle the overall scope of the restoration, as well as, I'm not going to say not damages, but when we have a particular case as it applies to what the senator is proposing in the legislation here, side by side with what's in the master plan, what's the difference?
I think the master plan itself is what addresses that. I mean, there's a series of projects that have been vetted. They're all intended to do restoration on the coast. They do, as generally, address those damages, I think, that are part of these suits, and there are projects in every coastal parish that could be used with this money, that could be done with this money in addition to other monies that come in. So it's certainly the master plan is what's intended to address that. That's vetted every 5 years now, every 6 years. That was changed last year in the law. So those projects are vetted, and we see what's best to address all the issues with the coast and to restore the coast as best we can.
Okay, and I've been sitting on this committee for a while, and I've been a proponent supporting the CPRA. So if this bill 440 passes as is, what will be, if any, adverse conditions to the overall master plan that this would adjust?
Are you talking about specific projects, or
I'm talking about in general, because this bill is talking about the whole state, not any particular project. So projects that's already ongoing as it is now are going to be affected by it, I'm sure. But the overall concept of what this bill does, how does it adversely affect the master plan as it is today?
I don't think it adversely affects the master plan in any way. It would actually enhance the master plan in the sense that our agency is always looking for an influx of dollars to do projects. Okay. We have more projects than usually we have money. And so this would be another income source to do projects that are in the master plan that right now may be on the books or that are in design that don't have enough funding for construction, those kind of issues. And so from that aspect, any kind of money that's coming into the program, the coastal program, is going to enhance the master plan in that sense that will allow us to do more projects in the master plan. I don't think it's going to have any adverse impact to the master plan.
Okay, and and you say any monies, and I guess this question will be back to the senator, where would monies come from?
From any funds or settlements.
Any funds or settlements that are proposed that are going right now.
Well, it'd be whatever in the future, but as of right now, there's no settlements.
So, in large, what you're saying, Senator, and thank you, sir, is that and we talked about the proposed settlement that we talked about earlier in several other pieces. So, from this point on, regardless of what happened in the last 5 or 6 years, whatever money is result of this settlement now, or any proposed settlement, is going to go into your fund to be distributed throughout the coast of the whole entire state.
Yes.
And we have how many?
Into these buckets and be ran by the master plan.
And I don't know if you know, sir, but you can probably tell me, of all the parishes that are involved in this particular suit right now, it doesn't include everybody across the state. Is that correct?
That's correct.
Okay, so you can understand, I guess, as I'm understanding pretty much now, I have a percentage in. And I'm going to say this mass is wonderful, but it's handsome, man. Believe me. What I'm going to say is, right now, I fish in Barataria Bay. And over the last 15 to 20 years, it's changed a whole lot. From coastal, problems to other problems associated with other parts of the industry and what have you. So it's incumbent upon me to do everything I could to make sure I restore Barataria Bay to what it was when I fished, as a young boy years ago. But if we do a whole process of litigation, and let's just say we recover $50 million in any type of whether it be a suit or some other type of way we recover that, I want to fix Barataria Bay, and I think you can appreciate that. But and I've also been in Terrebonne Bay, and so I understand how it's how the difference is from there. But you're saying that now, once we go through this process of 8 or 9 years, and there's any type of funds or resources available to mitigate it, now I got to cut it in 10 pieces to spread it all along the coast of Louisiana.
Well, sir, basically what I'm trying to do is, if you do one thing in one parish, somebody does something else in another parish, we're going to lose the whole game. All that money's going to be wasted. The master plan fixes it to where we can start saving our coast by doing different divisions that can create more land. Diversion canals coming out of Mississippi River, putting silt back into those areas, just like driving the Grand Isle. I remember as a kid, just like you're saying, going to Grand Isle, and you go over the Leeville Bridge down there, they had cattle grazing on both sides of the bridge. bridge. Now it's nothing but water. Just in the last 4 or 5 years, which no oil companies have been around, in the 4 or 5 years, if you look at the new Highway 1 and look at that interior area between old Highway 1 and 1, I've watched it wash away in the last 5 years. Totally. It's just washing away because we have no more silt coming down the bayous to feed our marshes. So we got to do this thing as a team, and that's what it's all about. It's about getting all the money put in the right place in the master plan, because I think the master plan can help save our coast and get these diversion canals coming back off the Mississippi River, feeding the bays that you want to feed in other parishes. But it's going to take time and a lot of effort from all of us.
Senator, I think I don't want to use too much of my time.
Yeah, well, I'm going to let you make a final comment because we got to move on. We have about a 30-minute time limit for each side, and we're about there. And I still have some 2-minute rule comments from some of our guests in the audience. So go ahead and make your final comment.
Mr. Chairman. All right. My comment is this. And when we're looking at your overall concept, it doesn't tell me that if I'm getting money in my parish for coastal restoration, or am I getting money in my parish for damages, and what have you. It doesn't have a distinction as to what is there. Now, as I know, in relation to what we talked about earlier in lawsuits, I sat on this committee 2 years ago, and I watched video of pipes and canals and what have you that was damaged and left that way, which, and from my recollection, is part of some other suits. And it's kind of like you only had so many parishes who decided to participate in this at that time when they all had opportunities to do so. So now we're at the point where we're having a small tract of progress in some area, but the point is we have a plan for what was ever there. So I don't believe that, and it's just my opinion, that when we look at the areas of the state who are adversely affected, when we make steps to mitigate that now we take and change the plan and divert it to some other program that may not effectively mitigate what we plan to mitigate. But I appreciate you bringing the bill, and some of this information as I go on, I'm going to get more, and I hope I get a chance to ask questions later. We have enough time. Thank you, Senator.
Thank you, Representative Lyons.
Thank you.
Members, we have some cards in support here willing to speak. Senator, if you don't mind, I'm going to get some other folks to fill that seat. To start, I know Mr. Briggs had some comments generally speaking on the bill, not specific to the questions that have been asked. We're going to start limiting it to 2 minutes, if you don't mind, so make your comment. We also have to move on to the cards in opposition, but we have several cards in favor willing to speak, so we're going to do that. Mr. Monclaw, if you don't mind joining me at the table, you'll be next. Mr. Briggs, on your comments.
Sure, Chairman Coussan, Vice Chairman Boryak, and members of the committee. My name is Gifford Briggs, President of Louisiana Oil and Gas Association, and thank you for the opportunity to visit with you this morning. I want to echo some of the comments of Representative de Villiers. The oil and gas industry is in dire need of a shot in the arm right now. In times like these, more than anything, we need predictability. We need to know exactly what to expect and who we are expected to deliver it to. That's why we support Senate Bill 440 and Representative de Villiers' amendment to clarify and reaffirm the legislature's original intent in the Coastal Zone Management Act that the state has sole enforcement authority over issues of state concern. When combined with Senate Bill 440, the legislature will have provided much-needed clarity and consistency in the statute. Removing the gray areas that have allowed private plaintiff lawyers to manipulate local governments into senseless lawsuits that have done nothing but drive people, jobs, and investments out of the state is extremely important. And while we're on this subject, those lawyers are about to come up here to this table in just a bit with pictures and stories trying to convince you that they're doing it for the coast. They aren't. It's all about the money, and we all know it. They're also going to try and convince you that this is about big oil. It's not. These lawsuits target over 200 companies. The majority are small and independent operators. Many have been LOGA members for years. They employ thousands of workers and support thousands of families with good, high-paying jobs. And they won't talk to you about that. They won't talk to you about my good friend Mike Monclaw, who is here with us today. Generational family business destroyed by the lawsuits. And no, they're not even a defendant. They may also come over to tell you that they're on the verge of a big settlement. They just need a little more time. Well, they've been peddling that snake oil since the lawsuits were first filed. 8 years later, these lawsuits have produced nothing for our coast, where oil and gas has generated over $230 million for coastal restoration and protection projects. They're also going to tell you that this bill is going to derail their supposed $100 million Freeport settlement with Freeport-McMoRan. The truth is that deal was dead the moment they announced it in the newspaper, before they had even talked to many of the people that were supposed to sign it. Lafourche Parish President R.G. Coussan is here with us today, and I'm sure he is eager to share more with you about that. The lawyers may also try to convince you that once the parishes are dropped from the suits, the state has to start all over again. That's not true either. When passed through the state, the Attorney General and DNR will continue on with the lawsuits.
Mr. Gifford, on your close.
Yes. The question that should be asked is, why is the state not here in support of the bill? Why is DNR? Why is the governor? Why are they advocating for the outsourcing of the state's enforcement authority to private plaintiff lawyers working for local government, and not here fighting for their own enforcement authority? Mr. Chairman, thank you for the opportunity today, and I will yield the remainder of my time to Mr. Monclaw and others that need to speak.
Mr. Monclaw, please introduce yourself to the committee. Once again, we're going to limit it to comments, and I know you have a lot more to say, and I appreciate that. But in the interest of time, the mic is yours.
I'll read fast. Thanks for having me today. My name is Mike Monclaw with Monclaw Energy Services out of Lafayette. I'm a proud third-generation oil-field Louisianian. My grandfather started Pelican Well Service in 1956. Now today at Monclaw Energy Services, we have several entities that provide those same well site services to the oil and gas companies of Louisiana, just like my grandfather and father did. The biggest entity for us was Monclaw Marine. From 2010 to 2014, we operated 11 barge rigs, employed over 300 workers, had annual payrolls to Louisianians in excess of $17 million, had paid taxes on annual revenues of over $40 million. Today, that business is completely shut down. 0 employees, 0 revenue, and we're having to sell barges at pennies on the dollar. Monclaw Marine is just one of many victims of this hostile legal climate in the state that continues to drive away investors and workers alike. Over the years, we've gotten used to being sued. First, it was a steady stream of Jones Act lawsuits. Our company averages about 10 a year, of which 99% are frivolous. Basically, just settling cases for less than it would cost to go to trial. We take care of our people, and in fact, our largest payouts we've ever had were to employees that didn't hire lawyers at all. These types of suits went after us and our insurance. But then came the tidal wave of legacy lawsuits, and now the coastal suits, which are the worst of them all. They are after our customers. These government-sponsored lawsuits have pushed the customer base out of our state. The inland water segment of our industry, which was the state's golden goose for decades, paying out billions in royalties and taxes to Louisiana, has basically been exterminated by coastal lawsuits. We've got to find a better way before all the jobs and investments are gone for good. I believe Senate Bill 440 and the amendments offered by Representative DeVilliers will help provide some much-needed stability and predictability in these lawsuits. If there's any merit to these suits, the state should be pursuing them, not a few plaintiff lawyers who stand and make a fortune. And if there's any money that comes from all this, it should go straight to the coast. That's just common sense. Without question, we need to do this. And we need to do it now before it's too late. I still get calls and texts from former employees that are tired of commuting back and forth to Texas. They want their Louisiana jobs back. Every single time, it's really hard for me to tell them right now, there's very little hope for that. I beg you and urge you to do the right thing. Support Senate Bill 440 for our coast, for our workers, for our economy, before it's too late. Thank you, Mr. Chairman and committee.
Thank you, Mr. Monclaw. You represent your family and your company well. Appreciate you coming to testify. I'm going to bring the next two folks to the table, also under the same time frame. Mr. Coussan with Lafourche Parish and Mr. Craig Romero with the Port of Iberia. Gentlemen, join us at the table, and please keep your comments to basically to address your issues in particular, and don't recover the issues that we've already talked about.
Thank you, Mr. Chairman, members of the committee. My name is Archie Chasson. I'm Lafourche Parish President. Here today to speak in support of Senate Bill 440, brought by my senator, Senator Mike Fazy. You know, and let me preface this by saying a couple of things. One, I've worked with and for parish government for almost a little over a decade now, starting my public service as the parish's coastal zone management director. So I'm sure President McInnis and President Lee Shang behind me can trump me in several other areas. I'm probably the only coastal parish president that has served as his or her parish's coastal director. So looking at the regulatory system, I know it quite well. And secondly, as of late, I've been branded as what Mr. Cormouche said a minute ago, as just another politician trying to be Mr. Oil and Gas and support the industry. You know, and I'm astounded by that because the major lobbying groups, one of the major oil and gas companies, and in fact, one of the trial attorneys supported the other candidate in my race. So if there's anybody in the room today doing it for the right reasons, it's me, because I have zero debt to repay to anybody. I'm here for the right reason. It's not politically motivated. It's about the place I live, the place I grew up, and 100,000 people that I represent as the parish president. So, you know, Senator Fazy brought this bill on Senate Natural Resources a couple weeks ago, and President Dove from Terrebonne and I went there and fought for the bill, but fought against Senate Bill 490. This bill actually sets up a framework where the money goes in to coastal restoration. If the opposition would have had it their way, we would have had this money go into buckets that would have supported economic development, would have allowed parishes to do stormwater, infrastructure, sewer work, telecommunications work. At what point did any of the oil and gas companies interrupt telecommunications work across our coast? You know, if we're going to believe that these lawsuits are about restoring our coast, then we should put the money where the coast needs to be restored. And as I said a couple of weeks ago in the House Natural Resources Committee, I'm in my percentages a little bit. These lawsuits are not about restoring the coast, because I don't think these lawsuits could find or restore the coast if they had two hands and a flashlight. These lawsuits are 50% politics, 45% smoke and mirrors, and 5% somebody trying to do the right thing. And I respect President McInnis and President Lee Shang and their parish positions that they think they need to do it. You know, and the fact of law, as Representative Landry brought up, that we may have the right. A federal judge may have said the locals have the right to enforce these things. But I can tell you from running a coastal department, we don't. Because if that were the case, we wouldn't have to sue the industry. A local program could bring an enforcement action against the oil and gas company for a permit that they didn't get, and we would be able to adjudicate it that way. But the fact is that when we try to do that, DNR in the state tells us we don't have that right. It has to become a state concern, and they have to handle the enforcement. They won't let us assign mitigation. They won't let us assign penalties. The state always handles it. So when we get to the amendment, Mr. Chairman, I'm going to support the amendment because I just don't think, out of principle, that we need to be suing an industry that has fed and fueled not only Lafourche Parish, but the great state of Louisiana, our country. So with that, thank you, Mr. Chairman.
Thank you, Mr. Chasson. Mr. Romero.
Thank you, Mr. Chairman. My name is Craig Romero. I'm from Iberia Parish. I'm the executive director of the Port of Iberia. I served as parish president of Iberia Parish for 9 years and was very active in the Polish Jury Association. Then I got elected to the state senate, served there from 1992 to 2008 when term limits went into effect. And the port that I represent is probably the biggest shallow draft port in the Gulf, in the state of Louisiana, and we're home to a lot of the inland barge companies, one of which is Monclar Drilling, and you just heard Mr. Monclar explain that their business is completely shut down. We have Parker Drilling, all inland barge companies we have. We have a couple of deep water companies, but Parker Drilling has a fleet of 13 rigs. You want to talk about put it in perspective? 5 years ago, Parker Drilling had 850 payroll checks going out of the office at the Port of Iberia. Today, there's 40 paychecks going out of that office at the Port of Iberia. All 13 drilling barges are parked at the Port of Iberia, dead in the water, literally. We have Coastal Drilling, 3 large barge rigs. We have Baywater Drilling. They come park theirs from time to time. Mr. Feasey, they're from Homer, but all inland barge. And that's what these lawsuits are targeting. It's shutting them down. And nobody's going to go and drill a well in coastal Louisiana when the government is telling you, we're going to sue you for things that you did maybe 40, 50, 60 years ago. If you came to this hearing 2 years ago in this building, you picked up on a lot of it. It was sort of scary. And coastal lawsuits is not the first scam to come to these halls in the state capitol. Years ago, when I first got here in the early 1990s, the Louisiana Department of Environmental Quality came out with a new program. They had discovered a new substance that was extracted from the ground when you drill an oil well, called NORM, naturally occurring radioactive material. Well, DEQ came out with this sensational scare, if you will. Coronavirus had nothing on what they were portraying at that point in time. Well, it didn't take long. Guess who had the only storage facility in the state of Louisiana to store this substance to save us all from the illnesses? the governor's brother, had the only storage facility in the state of Louisiana. So, you know, and it goes on. Fast forward, you had an attorney general sign contingency fee agreements with trial lawyers to clean up the oil fields in Louisiana. Guess what? Those contingency fee agreements assigned the trial lawyers to establish the value of the cleanups, not environmental scientists, trial lawyers. You know, the entire masquerade of coastal lawsuits today is not about restoring this coastline. It's about legal fees. The Powerball payout doesn't come close to the legal fees involved in these coastal lawsuits. If you know anything about the values they're throwing out, the man sitting behind me throwing out a $9 million figure. I'd like to see those timesheets.
We don't want to go to the timesheets today, but
well,
because
one sentence is all I have left.
Yes, sir. Thank you.
The charade of these lawsuits, urging parishes to hurry up in filing their own lawsuits, is simply a ploy to maximize legal fees, simply because you can't do a contingency fee contract with the state. And in closing, the entire settlement theory being represented by this group of trial lawyers is no different than chumming fish when you're fishing offshore. You're trying to get the fish to bite. If they can get a few parishes to bite, Iberia Parish voted unanimous, 14-0, opposing the lawsuits, and sent a message to those that are involved. Thank you very much for allowing me to come here. Apologize for getting a little emotional.
Thank you for your passion, Mr. Romero.
This is our way of life, like a lot of you in South Louisiana.
Thank you both.
Thank you.
The remaining cards I'm going to read in, and then we're going to move to our opposition. Since we just heard from the parish presidents, what I'd like to do is hear from the first two parish presidents, Ms. Shang and let's see. Mr. Guy McInnis and Ms. Shang, if y'all could, I'm gonna let them speak first, and then we'll let you basically finish out the time frame with as much time as we have for you. Ms. Shang, if you can join us at the table. We have a bunch of cards in opposition, most of which wanted to speak or want to speak. So we're going to keep our time frame as sharp as possible, and knowing that we still have to give everybody else an opportunity. Ms. Shang, on your testimony, please.
Thank you for allowing me to be here to address you. Local government has been given this right to enforce our coastal zone.
Could you introduce yourself?
I'm sorry.
To the committee? Yes, ma'am.
Cynthia Lee Shang, Jefferson Parish President. Local government, as I said, has been given the rights to enforce our coastal zone, as along with all the other rights that we have to ensure our citizens' protection, our quality of life. And I know my time is brief. I will just have to say, with all due respect to this body, to this process, the only word I can say is the timing is curious. It's the only word I know how to say this. We have been at this for 7 years. And now when we have a settlement, that we're talking about a settlement to finally get through this legislation comes up. It's disheartening. It's a punch in the stomach. And it comes at a time, again, the word is curious, where, and I don't want, we're passionate about different things. There's a global pandemic going on right now. And Louisiana leads the country per capita because of the Jefferson and Orleans numbers. I was a new parish president. Our council was new. We are up to our eyeballs in fighting the coronavirus. 745 is the number that I had to see on the dashboard on April 2nd for new cases in the parish I had to represent. And then I had to brace myself for what I knew to come next. 2 weeks later, 37 deaths. The day before that, 24 deaths. The day after that, 14 deaths. So our council, my new administration, again, is up to our eyeballs in trying to set up a blood drive, in trying to set up a test center, in trying to set up a call center, in trying to communicate to our public, in trying to help our business. I am not sleeping for those weeks. And 2 times in this 12 weeks, and with all due respect to everyone in here, I know we love public service. I have been fortunate to be a public servant at the federal level and on the council for 20 years. The past 12 weeks have been the busiest 12 weeks in my life. And 2 times in 12 weeks, I've had to come up here to fight about this. So we all can be passionate about things. I'm passionate about this too. The curious timing of this legislation being proposed. And I know my time is probably up. Thank you very much.
Parish President, thank you for joining us. You are well represented by your Jefferson Parish delegation, and they have communicated to the whole body the issues that you're facing and Orleans Parish is facing with regard to the COVID-19. You know, these bills, most of these bills, if I'm not mistaken, were filed prior to the issues with COVID-19 affecting the legislature. And as I understand it, there were bills or a bill filed also by the parties aligned with your parish relative to the settlement of the lawsuit. So, you know, the curiosity, while it may, you know, kind of look apparent as that's curious, it seems like it's just one of the issues that we're facing, you know, as part of our representation for our community. So I appreciate your testimony.
Absolutely. And with all due respect, our council during this time did not take up controversial issues. We were one of the first parishes to conduct a Zoom meeting in this state, I believe. And I work closely with the council. Our chairman is behind me. Purposely part of those discussions to not take up controversial issues during this coronavirus time that our state is facing. But thank you.
Thank you. Yes, sir. Please introduce yourself.
Thank you. Guy McInnis, St. Bernard Parish President and CPRA member. I can't believe we're here. I really can't. If you don't want to get sued, don't pollute. And what does pollution affect? It affects the citizens that none of you seem to be representing. I hadn't heard the citizens' concern today at all. What am I hearing? Big oil. Little oil. And look, I get it. I get Senator Facey. That's his community. He grew up there. His business is in oil. I get it. But I'll tell you what you didn't hear him say, or President Coussan's a friend of mine. He does a great job in his position, and we all get along and we work together. He's not rejecting any money coming out of a settlement. I'm ticked off that we have to give them money out of a settlement that we've been working for 8 years. Win, 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 win. Never lost. And we're not going to lose in the legislature. And you guys know it. And this is a waste of our time. And one of the most, largest disasters, this global pandemic in the history of the world, and I got to be here fighting for our right in St. Bernard Parish to sue a company that polluted our parish. Yes, 50 years ago. And we're still paying for it. We still got canals that were dug that wasn't filled in. We still have sites that were contaminated 50 years ago. And guess what? They're still contaminated today. It's amazing to me that we're here. And I apologize, Mr. Chairman, for my passion on this, but golly, represent the citizens. The people who have the small bank accounts, the big bank accounts that got some of you elected, tried to get a governor elected. You lost through the election. You can't make it right here. Money, more money doesn't mean that, you're right. It just doesn't happen that way. I get that local communities on the coast that rely on oil and all of the jobs that they create. But at what point do they not have to follow the law? At what point, Representative Valier, and really, I get what you're saying. At what point, how many, jobs that they have to create to pollute? I don't care if it's 100 years ago, 100 years in the future. They polluted. And they got to pay for it. If it's a friend of yours, make them be accountable in a correct way. We all ought to be able to get in a room. We're going to disagree. My wife and I disagree all the time about where we're going to eat. But we eat. This settlement's going to happen. President Coussan, President Dove know it. And they're not going to reject the monies they're coming from. And I promise you that. That's why they put forth 440. Our agreement puts 100% of the money into the coast. 70% master plan, 30% consistent with the master plan. If I work so hard to get a settlement, let's say it's $4 million. My percentage is nothing compared to Terrebonne, Lafourche, and St. Mary. in my parish, but I need every dollar. Representative Kerner, you hit the nail on the head. We can't afford to match, to put up matching funds. We had to use the BP settlement, $6 million we got. But we leveraged that and we turned that into about 35 or 40 million on our coast, thanks to CPRA and their hard work.
Mr. Parish President, on your closing, please.
Thank you, Mr. Chairman. I'll just close with this. I'm here in opposition to 440, but it's not 440 anymore. To answer your question earlier, this is SB 359 after this amendment. It's just a backdoor way to get back to the Senate. Senator Allen said that he would not support it going back. This is ridiculous, and I would ask each and every one of you to think about the citizens you serve, the damages that were caused, and what's the remedy. This is not the remedy. This is selling out to your citizens. Thank you, Mr. Chairman.
Thank you, Mr. Parish President.
Thank you for your
Appreciate
service.
both of you coming. Mr. Carmouche, will you join us at the table? I'm going to read some cards, some of which would still like to speak, but Mr. Carmouche may take up the remainder of the time. We have Scott Wilfong, Republicans Protecting Property Rights, Mayor Tim Kerner Jr. from Lafitte, here and wishing to speak. Jimmy Faircloth, here and willing to speak and provide information if requested. Sean Turner with Vanishing Paradise, willing to speak, wishing to speak. Councilman at Large, Ricky Template, here and wishing to speak. Dan Robin Jr., not willing to speak, but president in opposition. Donnie Robin and Associates. Jennifer Ansardi, here for Jefferson Parish, here not willing to speak. Bernie Roussel, here in opposition, not willing to speak. Marissa Turner, here in opposition. Polly Glover, representing herself. Richie Hike Jr., representing Morrow, Ryan, Bassett, and Hike, in opposition. Steve Cochran, Restore Mississippi River Delta. And Guy Cormier with the Police Jury Association of Louisiana, in opposition and not willing to speak. Mr. Carmouche, we'll give you the floor. And let me give you a time frame. I'm looking for the chairman of insurance, who's going to have the jurisdiction to boot me out of this room at 10:30. But given the circumstances, I'm going to give you as much time as I can until he starts giving me the evil eye. But that basically between 5 to 10 minutes on your closing, which is I think as much time, and I'll give some questions as well for you, which I understand they do have some questions for you from our members.
And I want to say, I mean, I have a lot more, and it's a shame that we have to go through this so fast when we're talking about something so critical to Louisiana. If everything the opponent said was true, then I would agree with him. And I'd say, pass the bill. But it couldn't be further from the truth. In 2014, this body told parishes to go forward. This body agreed. It had in the bill the same thing that you're trying to pass today. They had in the bill, and they said, let's take it out and let them go forward and let them move. But the only thing we want is O in the statute. Why do we want O? Because we want to make sure that every dollar that's given to these parishes go to coastal restoration. You know what the parish said? We agree. We agree. Put it in O. It's in the law. It was put in 2014. Every dollar that's awarded, for coastal restoration goes to coastal restoration in these parishes. Not $1 goes to lawyers. Not $1 goes to lawyers' cost. It's not true. I'll run through 440 real quick. I agree 5% can be pulled off. That's 5% gone. If it goes to the way they want it to go in the CPRA. Why would we want to do that? You don't have to. The money can go through the Treasury Fund and be held for coastal restoration. We're 100% under O. Where does the money go? The money could be spent in Ascension Parish. There's an $876 million project in Ascension Parish. It's under coastal restoration, but that's not what these lawsuits are about. The lawsuit is actually to restore the coast. But you're giving 50% of the money under 440 to CPRA, and I'm not bashing CPRA, but we know, we saw it, they don't have the money right now. But they could grab the money of 50% and use it, not even on coastal restoration. This is their projects. Take for Cameron Parish. You got sites that have been sued upon, that have been horrifically destroyed, land loss, polluted. None of the money will go to those sites. What you're going to cause of these parishes to start, the goal of this is to have the parishes start fighting and the state start fighting. This bill's not for coastal restoration. It's not true. We already have something in the law for coastal restoration. I want to make it very clear to Mr. Rero, this is not a legacy lawsuit. There's no contingency fee contract. Said it 50 times. I'll say it again. I'll go under oath. I'll say it. The only way this happens is the taxpayers have to pay the bill. 440 will kill the Freeport settlement. I'll go through that. 440 will prevent any future settlements because I'm the one, nobody else in this room met with the oil companies but me. Tyler Gray wasn't there. They didn't invite him. I don't know why, but I met with all the major oil companies. I met with Freeport McMoRan for 2 years. 2 years. You know what the conversations were? Help us come up with a structure and a plan so we can actually agree. Because my opinion is you have no defense. We're not talking about the merits, right or wrong. We're talking about how can we have some place where coastal restoration can get done, but be a business deal, not a beatdown. Because I agreed, I'm not here to beat down the oil companies. They can say whatever they want about me. The oil companies know that because I sat with them for 2 years talking settlement. I said, listen, what I want to do is I want to create an asset by coastal restoration. Gary Graves passed a bill 4 years ago on creating credits, environmental credits, that is an asset for the oil companies. I said, let's use that avenue to where this coastal restoration, you can get it back. You can pay for coastal restoration in Louisiana and have an asset. That's what we want as parishes, and they want their property restored. They don't want to beat you down. They want you to come back. They want you to create land and an environment where you come back. You know why? Because there won't be any more liability. That's the way we restore Louisiana's jobs. We got great independents, great contractors who can't come back in these areas because of all the liability. Well, this solves it, right? The lawsuit solves it. You settle, done. No more liability. Guess what? Coastal Louisiana is open for jobs. That's what this does. That's what this does. And the oil companies know it. And they want something to pay for it. And this doesn't give them that. This gives them the biggest thing. I want to know where the money's going. I'm not going to pay for something that I don't know that the coast is getting fixed. Well, on the 440, it could go to Ascension Parish. I have nothing against Ascension. It could go to Assumption Parish. They're now in the coastal zone management since 2012 for the sinkhole. So this bill does nothing that they want to pay for. So you're killing the lawsuits. I have an example real quick. I mean, everybody thought $20 billion was good for Deepwater Horizon. You saw it. That's why you could see the contamination. We did an example. This is all their data. This is not my data. 3.19 million barrels of oil was spilled in the BP oil spill. That's 8 Superdomes. Horrible, horrific. What this lawsuit's about, using their data, not mine. 12 billion barrels of waste discharged in the marshes of Louisiana. 12 billion barrels. Their data, their admission, 30,000 Superdomes. But yet today, BP, we hold them accountable. Today, 30,000 Superdomes compared to 8. You're going to tell the citizens of Louisiana you don't want to hold them accountable. That's what they're asking you to do. 32 hearings in state court, 13 hearings in federal court, 6 trial dates. Every time I got a trial date, they continued it. Removed us to federal court twice. Who doesn't want to face a jury? The oil companies, because they're wrong. They're wrong. And they know they're wrong, so they can't do it. I want to go through this very quick. I don't know how to say it anymore. There's a settlement. Freeport signed the settlement agreement. If the parishes, Mr. Chasson doesn't want to sign, with all due respect, his counsel can sign. The DA in Terrebonne can sign. Or if they really just don't want the money and say we don't want it, then the governor can sign. The DNR can sign. The Attorney General can sign. So if they don't want the money, don't participate. But the rest of the state and the coast of the state shouldn't suffer. I agree with Freeport because I knew I would be here one day. I knew for some reason I'd be here. I told them on the $100 million, although the law, I could never take a fee on the $100 million, but I could ask a court for a reasonable attorney's fee from them. I said, I'm going to be here. I don't want $1. Because if all we collect under these lawsuits is $100 million, we're lost. Because I know the damage they caused. I know what I can prove. I know what they did. I know their admissions. I know what they're willing to pay. Not $1 of the $100 million. None coming to these lawyers. So it's all about legal fees and lawyers. Not true. We're at the mercy of a court at a later date. But as to Freeport, not $1. Not $1. These are the signatures. I can't say it anymore. I mean, if I go to Terrebonne and said I got money for you, they're going to say no. If I go to the governor, you think he's going to say we don't want it? Freeport signed the settlement. They got a check ready. $100 million. For example, 1,200 new jobs, $57 million in wages, $16 million in tax revenue, $174 million in additional spending, $1 billion. It goes on and on and on and on. This is that will generate jobs for them. They will come back to these sites. There's specific examples. I don't have time to go through them. If you want me to tell them, call me. I promise you, I'll give you 50 of them where they came back to Louisiana after liability was gone. What does this do? 440. $50 million can go anywhere CPARA wants it to go, not on coastal restoration. Today, all money's been spent on coastal restoration in the impacted parishes. $25 million now split between the parishes. Get 2% each for coastal restoration in their parishes. 8 years of litigation, the money gets taken away and goes somewhere else, and 5% of the 50 can be swept. The other one, the parishes have to actually come up with money. Or the $25 million just sits in a fund. And or maybe there's an incident in St. Tammany where there's some money put in and St. Tammany can match this fund. So the money coming from coastal restoration now is yanked out and goes to St. Tammany. We'll run through these real quick, but I want to show you what these lawsuits are all about. Oh, it hasn't been up there? Can you turn on the PowerPoint? This is 1971, Plaquemines Parish. This is how specific these lawsuits are about. The triangles are oil wells. This is specific. This is where all this waste was dumped. This was land. Now water. What's the defense? None. Cameron, Crab Lake, 1974. Discharge millions and millions and millions and millions of barrels of produced water at this site. Illegally. 2012, water. (2010), Plaquemines Parish. Why is there land all around the site? We could say subsides. Why do we have this big hole? because they admit they produced millions of barrels of waste and dumped it in this trapped area. Their admission, not subsidence. Some of it probably is subsidence, but that's not what they're paying for. And the lawsuits are very, very specific. This is what, if you vote today, this is what you're going to be left. You're going to leave this. Today it is in the environment. This is what we're talking about. But they shouldn't clean that up. And under the law, they had the responsibility to pick it up when they left. And this is left in the marshes of Louisiana. Over and over again. Knowledge, go look at the Thumbs video. They knew going back to 1962 to directionally drill. In California, they drilled 11 wells from one spot, 1950. Research done by Texaco, Humble, Unocal, Chevron, Mobil, and Shell. They got bigger research centers than 3 times the size of LSU. They figured it out in 1960 for California and said, we know how to solve the problems of subsidence. We use saltwater injection wells. We don't discharge overboard, and we inject the water back. That's what they did. You know what they did in Louisiana? Amoco, West White Lake Field. They did exactly what they learned in Thumbs in California in 1962. They drilled wells. They dredged one canal and drilled all these wells directional. You know why? Because it was their property they owned. Let's go to property they don't own. So this is property they don't own in West Hackberry. What did they do? Dredged a canal. Every well. Didn't directionally drill. What happened? Land loss. What happened? Didn't inject the salt water, didn't inject the waste, discharged it overboard. Did they know? Yes, they knew. Shell Oil Company admitted they were violating the law in the coastal zone. Admitted they violated the coastal laws in a division. Knew there were going to be problems. If someone actually wakes up, we will be held responsible. But we are saving the money today. That's in their own internal memos. Thousands of these memos. I wish I had time to go through each one of these. You want to know why in Texas? You want to know why they're going back to Texas and drilling Texas? There's no liability. You know why? Because the state held them accountable. This is pits going back to 1950. They're lined. You know how many pits we had in Louisiana lined? None. None. That's Texas lined. That's Louisiana. Not lined. Waste discharged in pits, seeping through the bottom, contaminating our groundwater, destroying our marsh, Louisiana, Jefferson Parish, Plaquemines Parish. Just that's oil. That's oil in an unlined pit in the marsh, leaking over. That's what the lawsuit's about. That's specific. You know what they did? Nothing. Walked away. No restoration, no permit to restore the property to its original condition as required by law. Louisiana, Lafourche Parish, it's the Chachons Parish, discharging that produced water waste into an unlined pit, killing the marsh. This is actually one of the sites that we're suing over. It's all water. You'll stick a stick down, oil. What did the sediment show? Sampled by us and the oil companies, highly contaminated sediment. You know where that was? Where one of those pits was. Now water. You can't see the pit. So your family goes fish there. They can't pull up aerials. Can't do that. What they do is they pull up crabs and fish from this site that these oil companies know through their own sampling is polluted.
Mr. Carmouche, you're talking about the merits of the action. Can we stick to the bills? We have a settlement bill and a procedural bill relative to local and state concerns. So try to tie it back to the bills.
If you get rid of the lawsuits, because that's what you're doing today, Go ahead. I'm sorry. Go ahead.
You want to say you're getting rid of the lawsuits? I think you know that the bill doesn't do that, but just go ahead. Continue.
The bill does that. How can you, if you take away, you know what it costs the state of Louisiana today? You know what it costs the state of Louisiana today? Not $1. Not $1. The Attorney General and DNR have been involved since the beginning. Have been in every meeting, have been to every hearing. Nothing's been hidden from them, from the parishes. They have been involved and they know everything. Have agreed on everything we've done. The best part about it is it hadn't cost the state $1. So you get rid of the parishes. There's a fiscal note that's done by the fiscal office of the state of Louisiana. It's going to cost $4.23 million per case. That's 42 cases. That's low. I say $16 million. Take the 4.2. It's going to cost the state millions and millions of dollars. They can't afford it. DNR already testified they can't go forward with this lawsuit. How's the Attorney General's going to come up with that money? The state, y'all going to make the taxpayers do it when it's costing them now. You pull back the curtain. Pull back the curtain. And what it's really about is Senator Hewitt's resolution. Dismiss the lawsuits. That's what will happen. So don't think these cases will go forward. It's already been said they won't. It'll be dismissed. So these cases will be dead. A settlement that you have right now, and these oil companies are on the verge. We're on the fourth quarter. We're on the end zone. We're in federal court right now. A court could rule tomorrow that we get to come back to state court, and they will settle. I promise you, they will settle, or they will go to trial and lose because they're wrong, and they can't win. So they will settle. Don't take that opportunity away for Louisiana. If they're right, then they can win in court. They got 193 lawyers, 60 law firms all over the entire country. They can win if they're right. They're asking you to be the judicial branch. You created the law that allowed and told these parishes in 2014 to go forward. That's the law you passed. And that's what you told them to do. And that's what they did. And they're winning. Don't come strip that right away because they're losing and they can't win. And then allow the taxpayers to have to bear the burden of paying for their problems. It's their problems. Lastly, I want to say this because I'm very proud of it. These parishes didn't run out and sue. They didn't run out and sue. Cameron, St. Bernard, and others. One person sitting here went in. Look, we're not really excited about filing. Don't file a lawsuit. Sat there and told them, don't file it. Don't hire me. Don't hire me. What I'd ask you to do, though, is to call at the time Chris John, Mr. Briggs, and the oil industry, and tell them to come sit with you. And the parish president, Guy McInnis, did it too. Have them come sit with you and tell them how they're going to solve the problem and come up with a plan for your parish. And I hope I never see you again. Those parishes invited the industry, Mr. Briggs, and others to go. They said, give us a plan. Not a week later, did they jump and file a lawsuit and hire a lawyer. Not 6 months. Not a year. 2 years later, they waited. 2 years. 2 years before I got the call back. I said, what happened? They never showed back up. They still haven't gone, and they're still denying. But yet, we're going to give them a pass.
Thank you, Mr. Carmouche. Don't get up. We do have a question from Mrs. Representative Landry.
I didn't know I got married, JP. Mr. Carmouche, I think there was a federal government study or report that found the industry partially at fault for coastal effect. I'm not sure if I'm describing that properly. I think the Geological Survey, could you just describe that briefly?
They did a study of the entire coast of Louisiana where they felt that they contributed 30%. So I'm not denying.
Who's they? Sorry, who?
The industry.
No, who did the report?
The industry was involved and provided that percentage. But my point being is that we're not suing over property and pollution or Mississippi River damage. We're very, very specific. We went through every piece of operation. It took us 8 years. Where they discharged the water, where's the permit that they obtained to restore the property. So are there areas in Louisiana, I could show you there are thousands and thousands and thousands of wells that we didn't even sue on. Probably hundreds of thousands of wells. Because we did the research and said, one, the operation completed before 1978, therefore we cannot sue. So it's not something that we went out and just sued every oil company, every operator in Louisiana. No. We researched and know specifically who violated what permit and what they obtained. So 30% though on the entire coast. So that was a study.
I recall that there was a government study. I couldn't remember what it said. And one quick follow up. I think the estimate is over $4 million a case. What is the aggregate if the state has to pay for all of these cases?
I think it's over $180 million.
That much, okay. As someone who is actually from Jefferson Parish and grew up in Mayor Kerner's district, I appreciate my parish president and everyone else who's here today, and I just wanted to say that. Thanks.
Thank you, Representative Landry. Representative Kerner on a question. Keep it quick. We are on at the end of our time frame.
Okay, thank you, Mr. Chairman. I will, and thank you, Mr. Carmouche, for being here today. Earlier, I heard the gentleman in the back say that I can't believe that if it's good, why is it the state of Louisiana here sitting on side you, action for this? But I want to reverse that a little bit. And if it's so good for the state of Louisiana and CPRA that's supposed to be getting money, why are they not here supporting the other ones? Could you answer me that question?
I think I understand. First, let me address the state. The state intervened. The lawsuits were filed under Bobby Jindal. The state intervened after Governor Everett became governor and has been involved ever since. They haven't disagreed. The Attorney General hasn't disagreed not once of what we filed. They actually signed a writ to the United States Supreme Court with us. So the state's been involved. Nothing's been hidden from the state. CPRA, I'm not here to bash CPRA. I don't know if they were even involved in the actual coming up with 440. But my point being, though, is in 2014, we all agreed. I think CPRA was in that hearing. The governor's office was involved and said all the money needs to go to the coast. It shouldn't go to other projects, or else we're defeating the purpose.
And that's my point. You sat and you worked with them all through the process, and now we're here, and they want to give it over to the state of Louisiana, and they want to give it over to CPRA, and none of them's here testifying. It just makes me look back at this bill that actually, has local government participating in doing projects, but local government doesn't have a dime. It has preferential treatment to contractors when that's unconstitutional. They got CPRA, not here, and they're supposed to be spending money. And we also got a fiscal note if we add it that went through. It was a dual deferment that went to the Senate Finance Committee. That's going to have to do the same thing on this one. I mean, the whole thing makes no sense to me.
Thank you, Representative Kerner. With respect, the state nor its agencies may support or oppose legislation, like the legislation we're dealing with, or any legislation that we're going to be dealing with. They can provide information, and the CPRA was here to provide information.
Well, I didn't see anybody for the Attorney General's office, Mr. Chair.
Thank you, sir. Representative DeVilliers.
Thank you, Mr. Chairman. I know we're running short on time. I just want to mention that personally, I really appreciate everyone's testimony here. Mr. Cormouche, I'd really like to sit down and visit with you and maybe go over more of your PowerPoint. And Representative Landry, I would really like to discuss with you more about Act 44 and in 2014 and the government study. I just want to be clear on my point, and I hope this doesn't put people in a bad spot. But we have got to do what we can to bring jobs back to Louisiana. And I don't mean not holding people accountable. It's not what I mean at all. And there are mechanisms set up today that allow us to hold people accountable for their actions. And I just hope and pray that we can come together with this piece of legislation, work through the process. There's not a lot of time left, even in this committee hearing, but even with this session. And hopefully we can come to some sort of agreement. Thank you, Mr. Chairman.
The only other response I'd say is I agree with you, and I'm telling you, when there's no liability, which I've been involved in, when there's no liability on a piece of property, I got best friends in the oil business. I called them and said, hey, there's no liability over there. You know what happened? They started drilling. Denbury, the person here in North Louisiana is dead in this field. Dead. Came in, had the oil company responsible, clean it up. You know what's there now? Denbury, $40 million plan. So, thank you.
Thank you, Representative Lyons. This will be the last bite of the apple. No more questions on the board at the moment, and then we'll get to some procedural matters.
Thank you, Mr. Chairman. Mr. Carmouche, you said earlier that the agreement, the $100 million settlement, I know it was testified earlier that it wasn't signed by all parties, but who signed it? You said someone signed it, did for Freeport McMoran?
Yes, sir.
So they signed the agreement saying that they were interested in making that settlement.
Yes, sir.
Okay, so, and that settlement was potentially for how much?
$100 million.
So as of we stands right now, you're saying that when we finish all the legislation here, that money is off the table. That settlement is off the table.
If this bill passes, it will be off the table because what they agreed to, this takes away. In addition, the parishes that signed because the money under O goes to restore the coast of their parishes. This takes that money away from them now. So why would they want to give money?
All that money is gone once this is over.
Yes, sir.
Basically gone.
Yes.
Wow. Thank you, sir. Thank you, Mr. Chairman.
Thank you, Rep. Lyons. Okay, members. Couple house cleaning issues. Representative Landry, to your request, not a motion, but a request, and it's distinguished without a difference, but for the fiscal note, the bill as it came over does not have a fiscal note attached to it. The amendment may change that analysis. However, it would be more appropriate on the floor rather than in committee to do that. So we'll dispose of the bills, whatever posture they are in, today, and then you can look at that later. We cleared the front desk. So we have a motion to adopt an amendment on the table from Representative DeVilliers. Okay, we've been discussing that motion along with the underlying bill, but we're going to dispose of the motion first. Representative DeVilliers has moved to adopt amendment number 2600. Is there any objection? We have Representative Kerner on the objection. Madam Secretary, please call the roll. So, and I'd like Representative Mr. Bosworth, please clarify the vote on the motion.
Thank you, Mr. Chairman. Members, a vote yes is to adopt the amendment by Representative DeVilliers, and a vote no is to not adopt the amendment.
Thank you. Madam Secretary.
Chairman Coussan?
Yes.
Yes. Vice Chairman Bouryak? Yes. Representative Butler? Yes. Representative Carrier? Yes. Yes. Representative DeVilliers? Yes. Representative Desatel? Yes. Representative Kerner? No. Representative Landry? No. Representative Lyons? No. Representative Mincy? No. Representative Reiser? Yes. Representative Romero? Representative Wheat?
No.
No. 7 yeas, 5 nays.
Thank you. And the amendment is adopted. We have a pending motion, we have an amendment that's being presented by Representative Boryak. Amendment number 2610, is it posted? You should find it online.
2610.
Mr. Bosworth, please explain the amendment.
Thank you, Mr. Chairman. Members, the set of amendments before you is coded 2610 in the top right-hand corner. It can be found online, and the substantive change is to add the language, and no district attorney shall have the authority to bring an action without the prior favorable vote of the local governing authority.
Representative Boryak, on your amendment.
So I think, I'm new to this, and after listening around the Capitol, I think the worst kept secret was that Representative DeVilliers would be bringing the amendment. The second worst kept secret was that I was going to be in a bind no matter what happened in the committee today. I have 2 parishes that have completely divergent wishes as it relates to these coastal claims. And I've worked with every one of the parishes that came up, and you're representing your people, and I respect that. We started at the same time in the parish administrator's office. What I would like in the amendment to accomplish is just to say it as plainly as I can, is twofold. I have one police jury that voted unanimous to oppose the lawsuit. The DA, who in statute had the authority to bring the claim, brought the claim in spite of their client's objection. So I want, and I know there's retroactive application relevant to this, but those local governing authorities who made those decisions in each one of those parishes to sue or not sue, regardless of how we feel about it, I feel, after watching all the 2014 testimony in every committee and every floor vote, they felt they had that right. So in one parish, the DA brought it, and I think that the attorney needs approval from the client to bring that claim. My second intent is these other parishes that had moved forward after 2014 and went through this process, I feel it pertinent to give them the opportunity to continue their effort. I represent, like I said, both parishes. This is the only way I think I make both sides mad, to be honest with you, with the amendment, which is not good politics. So you might not see me here very much longer. But I feel in my heart, after thinking about this for some time, that's really the crux of the amendment.
Representative Landry, on a question.
Yeah, I just wasn't sure if it's too late to ask the representative from DNR to speak briefly.
On this amendment? Yeah, we're on the amendment now.
We're on Ryan's amendment?
We're on Representative Boryak's amendment.
Okay, no, sorry. When we go back to...
Thank you.
Step
Okay. We have a motion to adopt an amendment by Representative Boryak. I have an objection by Representative Kerner. Representative Kerner, would you like to speak on your objection?
I just feel that right now it's up to the district attorneys, and all you're doing is open up a can of worms for people the fighting parishes. I just feel it's a bad amendment.
Thank you, Representative Kerner. The board is clear on the amendment. Mr. Bosworth, clarify the vote.
Thank you, Mr. Chairman. A vote yes is to adopt the amendment 2610. A vote no is to not adopt the amendment.
Madam Secretary, please call the roll.
Chairman Coussan?
No.
No. Vice Chairman Boryak?
Yes.
Yes. Representative Butler? No. Representative Carrier?
Yes.
Yes. Representative DeVilliers? Yes. Representative Desautel? Yes. Representative Kerner? No. Representative Landry? No. Representative Lyons? No. Representative Mincy?
No.
No. Representative Reiser? Yes. Representative Romero? Representative Wheat?
Yes.
Yes. 6 yeas, 6 nays. It's tied.
When a vote is tied, the amendment fails to pass. Thank you, Representative Boryak, and certainly no one questions your representation of both your parishes and all of your constituents. So we thank you for that. We are back on the bill as amended, and we're going to ask the author to come back to the table for closing comments. Senator Fazy, on your close.
Thank you, Mr. Chairman and members. I've grown up in Terrebonne Parish all my life. I've seen a lot of lost land due to the Mississippi River being diverted, which nobody wants to bring to point. It seems like that 440 is basically to save our coast and put everybody together. I guess with the amendment, it puts everybody on the same track. So all I have to say is we need to vote our conscience on moving forward to save our coast as a team. And by this bill passing does that and gets the lawyers out of it, that the state can handle any lawsuits that may come aboard or in place for the any damages done by anybody, whether all companies or whoever it is, to our coast. That's why we have a state law that puts them in position to bring all that forward and get anything done wrong put in the right perspective. But if we get to where we got each parish doing its own thing, we're going to go for total devastation on trying to save what we making out to do to save the coast. Because if we're all going in different directions, it's not going to work. The biggest thing we got to do is stick together and make sure that we get the master plan in place to keep going like it's going, because it is working. Thank you, Mr. Chairman.
Thank you, Senator. Representative DeVilliers has made a motion to report the bill as amended. Do I have an objection? We have an objection from Representative Kerner. Mr. Bosworth, clarify the vote. Yep.
Thank you, Mr. Chairman. A vote yes is to report the bill as amended. A vote no is to deny the motion.
Madam Secretary, please call the roll.
Chairman Coussan?
Yes.
Yes. Vice Chairman Voryak? Yes. Representative Butler? Yes. Representative Carrier? Yes. Representative DeVilliers? Yes. Representative Desautel? Yes. Representative Kerner? No. Representative Landry? No. Representative Lyons? No. Representative Mincy? Yes. Representative Reiser? Yes. Representative Romero? Representative Wheat? Yes. 9 yeas, 3 nays.
Thank you, Senator. The bill moves as amended.
Thank you all very much.
Thank you, members. That disposes of our agenda. We appreciate everybody's work through the process today. I have a motion to adjourn from Representative Mincy. Hearing no objections, we are adjourned.
coming.